may have made rulings on form questions, foundation questions, given the attorney's direction to move in a different direction or approach a problem from a certain perspective. I don't think they were substantive in nature. It was more technical. I think some of the other sidebars had to do with the attorneys putting me on notice about things that are likely to occur or may happen. But I don't remember any other sidebars that involved the inclusion or exclusion of meaningful substantive evidence over the objection of one of the parties. Anybody remembers something that they want to make a record of, you have an open invitation to do so. I also want to circle back to exhibit number 24. Yesterday, there was a request to seal a trial exhibit. Neither of the attorneys have provided me with any law authorizing it. And, unless you do so now, I conclude that you still do not have supporting authority. As a judge, I
believe yesterday I articulated, I think exhibit number 24, I would just note chapter 950. I appreciate it's probably not my space to make that argument, but it will nevertheless. Chapter 950 involves the dignity of human beings, particular victims, and in my opinion, the photos I think we're talking about the photos.
Yes.
Those photos being made public is contrary to respecting the dignity of those people that have that right.
I understand the thought and the sentiment. In a way, as a human being, I agree. However, as a judge, I have to follow the law when it comes to sealing records. And judges are very restricted, at least in Wisconsin, about what records can be sealed from the public. And the authority is defined specifically by statute. Things like juvenile records, trade secrets, social security numbers, pre-sentence investigation reports, psychological studies, things like that are all defined in statute that a judge either is permitted to or is required to seal. Judges do not have broad authority to seal records that the judge thinks would be appropriate or to protect the interests of individuals, unfortunately. So because this is a trial exhibit, it's been received into evidence, because this is a public trial that does not involve a enumerated statutory basis for sealing, I don't have the authority to do so, even though I may prefer to do so. I simply just don't have the authority. So the request for sealing is denied on exhibit 24. I provided the attorneys with a printed version of all of the proposed verdict forms. Did anybody have any objections?
No.
I don't.
Okay. So those will stand and be submitted to the jury. Is there anything else you want to address before we get back to the jury instructions? Okay, hearing none.
Actually, can we approach quick, Judge?
Yes. All right, let's table the sidebar for a moment. I want to get these jury instructions done so I can have them printed. We left off at 1072, the attempted crimes for counts 2 through 5. Mr. Nelson, you had a lot of objections yesterday that applied to 1017. Those same objections would apply to 1072 because same issues exist in both instructions. So I've noted all of them for purposes of preserving the record. Are there other matters that you want to address in 1072?
Yes, Judge. In 1017 as well as in 1072 regarding the matter of second-degree reckless homicide on page 10 when you're talking about the homicide, and on page 20 when you're talking about the recklessly endangering safety, both in the second-degree matter. Both of them merely say the difference between first and second is the additional element. There is no mention in that discussion of second-degree reckless homicide, nor mention in the second-degree reckless endangering safety that it is the state's burden to prove beyond a reasonable doubt. I appreciate that it is in first-degree reckless homicide and it is in first-degree recklessly endangering safety. However, I think not including it in second to make sure clear that the burden is on the state is a direct contradiction to the state v. Austin 349 Wisconsin second 744 case that we've been discussing. This mistake, error in the instructions that were included is, I think, exactly what Austin says on paragraph 7, mentioning the jury instructions in Austin. Said, however, there was no mention of the burden of proof relative to self-defense. It talks about that in the context of recklessly endangering safety. And later on page 17, it talks about the standard instruction implies that the defendant must satisfy the jury that he is acting in self-defense. In doing so, the instruction removes the burden of proof from the state to show that the defendant was engaging in criminally reckless conduct. So I'd ask that on page 10 and on page 20, we're discussing the second-degree reckless homicide and the second-degree recklessly endangering, that Your Honor add the words that I believe were added in other aspects, and that Mr. Miu was not acting lawfully in self-defense.
All right, the objections noted. I am declining the request for the modification. Again, this comes from the pattern standard language from the jury instruction book, authored by the jury instruction committee. It's a committee of multiple judges who have studied these issues and have vetted appropriate language. The self-defense language appears in connection with first-degree reckless homicide and first-degree recklessly endangering safety. The jury will be instructed that one is not engaging in criminal reckless conduct if they're acting in self-defense. When we get to the second-degree versions of those offenses, the instruction makes explicit reference back to the wording from the first-degree offense, but simply tells the jury that the absence of utter disregard for human life, but the instruction for the second-degree offenses instructs the jury that they do not have to find the utter disregard for human life. So it's incorporating by reference the first-degree language. I think it is adequate. I think it is accurate. The attorneys will have ample opportunity to argue the respective points, including the importance of the self-defense being disproved by the state beyond a reasonable doubt. What's next?
That was the only additional request after reviewing the instructions. Judge.
Okay, and then last night we went through all of the other instructions. I'll give again another open call to additional instructions that you think, additional removal of instructions. Is there any changes, objections, concerns that you have to the jury instructions as presented?
Judge, regarding the excuse portion, I agree you can take that out. I'm not going to argue that in any way of provocation. So it was one of the bracketed instructions. It's on page 3.
Yes.
It's a single sentence paragraph.
It is removed. Anything else from the state?
Not on jury instructions.
Mr. Nelson?
No, Judge.
Okay. So I'll have the instructions finalized. My intent is to read before you argue. I'll also have the instructions displayed on the monitors so the jury can follow along. The jury will be provided with a few copies of the printed instructions in the deliberation room for their reference. Mr. Anderson, at sidebar, you said you had a motion to make?
Yes, Judge, I have a motion to strike one of the jurors. It was brought to my attention yesterday that during portions of testimony yesterday, one of the jurors was sleeping for an extended period of time and to the point of nodding off and then jerking awake. Both sides have a right to a fair trial, which includes juries that are attentive. I'm looking at Wisconsin Supreme Court case, State v. Novi, 346 Wisconsin 2nd, 289. It could, if there's a conviction, the defense could also try to argue that it violated defendant's right to fair trial. So obviously we want jurors who are paying attention to the evidence. So it's a two-step inquiry. One, it's a fact determination whether the juror was actually inattentive to the point of potentially undermining the fairness of the trial. And 2, whether there's why this is the appellate review standard if there's prejudice as a result.
Which juror?
4021.
Judge, we don't agree. I'm not looking at them, so I don't agree with the factual basis.
Mr. Anderson, if you want to pursue the matter further, you'll have to provide a witness.
State calls Investigator Schultz.
Investigator, please stand, raise your right hand and be sworn.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Please have a seat in the witness chair. Mr. Anderson.
You've already testified, but can you state your first and last name?
John Schultz.
And were you present throughout testimony yesterday?
Yes, sir.
At portions of the trial, were you watching the jury?
I was.
Was there a specific point during trial period of time, I should say, where you noticed a concern about whether a juror was paying attention?
Yes.
What did you notice?
I observed one of the jurors with her head down and would startle up with her head on numerous occasions.
What kind of time period, if you can recall, was it like 10-minute time period, half hour, longer?
About an hour.
And she was dozing off and appearing to start awake
Yes.
multiple times?
Yes.
And from reviewing our jury list in our office, we believe that to be juror 4021.
Correct.
Nothing else, Judge.
Mr. Nelson?
What time did this occur?
I can tell you during what portion of the trial, sir, but I don't recall the time. I apologize.
Just yesterday this happened and you don't know what time it was when it happened?
Correct. I can tell you the portion of the trial.
Let's start from there. During which witness?
Lieutenant Hart.
And during Lieutenant Hart's direct exam or cross exam?
It would have been during her direct exam.
And that was the before the video or after the video?
During the video.
So was it during the exam or during the playing of the video?
I apologize. I think I'm getting confused. It was during the playing of the video,
Was it at any time other than during the playing of the video?
not that I observed.
When you made these observations, you were sitting next to attorneys representing the state?
Yes.
Did you make note to them, pass a note, give an elbow, whisper in an ear?
No, I told them after or during a break.
So you made this observation while it was happening and you just, for lack of a better term, sat there and let it happen?
Yes,
Didn't bring it to the attorney's attention?
I did during the break.
When you say the break after the playing of the video,
I believe so, yes.
was there a discussion about whether the state thought the juror was on the state side or the defense side?
No, sir.
What was that discussion? Who did you tell?
During the break, I just told the attorneys that I observed a juror who I believed was sleeping. But I noted that I believe she was sleeping and not just closing her eyes because of her head quickly coming up like you would when you startle from waking.
And did you, at the time you didn't, your estimate of the time is fair to say rough.
Yes, sir.
You, during the actual live testimony from Brandy Hart, you didn't make an observation of any of this, correct?
Yes, sir.
It was correct. It was only during the playing of the video.
Correct.
It was only during a portion of the playing of the video.
Correct.
And your observation was just as you said, she had her chin tilted forward towards her chest at a couple of times during the playing of the video.
Yes, sir. Her chin tilted, eyes closed, and then head would come up quickly.
And when her chin was down and her eyes would close, would that last for a moment or would that last for 10 minutes or you don't know?
I was not watching her over 10 minutes, so I would say a moment.
Okay. So her chin would go down for a brief moment and then she would bring her head right back up. That's what you observed.
Yes, sir.
You didn't look over and see her chin down with her eyes closed and then look over and see her chin down with her eyes closed and then look over and see her chin down with her eyes closed. Agreed?
Sorry, I think I'm getting confused. Yes, that is what I would see.
I'm trying to figure out this, whether or not you observed her chin down, eyes closed, and she stayed in that position for some continued period of time, or whether you observed her chin go down, there was a startled moment, her chin would come up, or whether you saw something else.
I understand what you're saying now. So I was intermittently looking over, and during that period of time, there was times where I would just see her chin down, eyes closed. I would look back and it would be that way, and then I would see her startle with her head up.
So you're not in a position to tell the court the length of time that you observed her to have her chin down with her eyes closed? Meaning,
Continuous? No, sir.
All right, you don't know whether that was for 5 seconds, 10 seconds, 10 minutes. You can't say.
Correct.
You just essentially noticed it a couple of times.
Correct.
And by a couple, 2 to 3, is that fair?
I'd say 4 to 5.
And of those 4 to 5 times, half of them were you saw her with her chin down and she didn't make a response, and half of them were when she had her chin, you saw her make this, what you've called a startled reaction up.
Yes, sir.
That'd be a fair estimate.
That would be fair, yes.
And the times that you saw her with her chin down and eyes closed, it was again just a brief glance. You weren't dialed in, focusing on her. Agreed?
Yes,
You agree with that?
I do agree.
Nothing else?
Mr. Jameson?
So the 4 or 5 times, is that when you saw the head jerk?
It was both. At times I would look over and she just chin down, eyes closed. And then I would look over again and I would see that and then see the head jerk.
And did you see that for what period of time approximately from when you first noticed that till the end? Was it half-hour period of time, 45 minutes, hour?
Approximately over an hour.
Were there, when you looked over, if you recall, was it one of those 2 states, or were there several times where you looked over and she did appear to be alert?
Those are the only times that I'd looked over.
So when you looked over during that period, it was either chin down or startling awake?
Yes,
Nothing else?
You said it was only during the playing of the video. Agreed?
yes,
You understand that the video was less than an hour, correct?
approximately an hour. Yes, sir.
It's about 50 minutes.
Yes, sir.
So based upon that, you couldn't have been observing this for over an hour. Agreed?
I object that we played it for 56 minutes.
The record's,
56 minutes.
it wasn't over an hour. Agreed?
Yes, sir.
And you can't tell the judge during those 56 minutes when you made the first observation. Agreed?
Agreed.
So you don't know if it was 15 minutes into the video, 30 minutes into the video. You can't say.
I cannot give you an exact time. No, sir.
And all you do is, you said you saw it about this 4 or 5 times, correct?
Correct. Yes, sir.
And you're not in a position to say whether her head was down for any continuous period of time. Agreed?
Agree.
That's all, Judge.
Thank you, Detective.
Thanks, Judge.
Down. Is there anything else you want to say in support of your motion?
Judge, the video is obviously very important for the state's case. It was only played once. Clearly, we don't have enough time to play it again in closing, given the length of it. That would be our entire closing argument. Both sides are entitled to a fair trial with an attentive jury. So I think I ask that the court strike juror 4021 as one of the alternates.
Mr. Nelson?
I don't think they've established a factual basis that she was sleeping. I think that there's reason to believe, but I don't think that they've established a factual basis of that.
I tend to agree that there are some clues to suggest that the juror may have been nodding off. There's certainly nothing conclusive, certainly nothing that would allow me to make such a significant finding. I'll say for my part, I was scanning the juror from time to time during the playing of the video as well. And my eyes were not fixed on them the entire time, obviously, because I'm trying to pay attention to the video, but I also was watching the jurors. I did not notice anything that would suggest somebody was sleeping. I have a different perspective than others. I'm not saying mine's better, it's just different. I did notice a number of occasions where people were looking down because they're writing on their notes, or they were averting their eyes, but they weren't sleeping. So I just say that to point out that there can be other alternative explanations for certain observations. The other point too is that even if we did have a sleeping juror, and even if that juror slept the entire presentation of the jail interview, it is a recorded interview. And if that juror ends up being one of the 12, that juror has the ability to request to watch the video. So it's not like live testimony that is lost forever. This juror, if they make it to the deliberation room, has the ability to view the video again and take that into consideration as part of her deliberations. So for those reasons, the request is denied. Is there anything else?
No.
All right. Anything else from the defense?
Just like a break before we get into openings.
We will, yes. All right, let's take a short break. We will resume at 8:45.
Oh. Well, that was a start, wasn't it? I'll just say this. Shout out to Murph's Turf. Murph's Turf asked a question in chat for me about what time is it kicking off? I was like, 9:30. It's 9:30 Eastern, 8:30 Central. I was like, I better set up because I'm on a call, so I was going to set up Law and Crime, and I saw this live. So had I not seen that message, Murph, I would not gone live. So shout out to you, and hello everybody. Hope you're all well out there. That was some bullshit. Like, this is something so easy. All that lieutenant needed to do yesterday, or investigator, whatever his name is to nudge the attorney and go, hey, look at that juror over there. She's sleeping. That attorney could have then said, excuse me, Your Honour, can we just have a quick sidebar? And then noted their findings. That's all it was. That's all was needed. You don't wait until the end, and then the next day then you bring it up. They didn't even bring it up last night. Last night would have been better than nothing. They don't bring it up the next day after you've been evaluating. Ho ho, ha ha. Hello, Eman Rezu. Did they watch that vid over and over Miu's toast? Possibly, yes. You think they're giving the jurors coffee, they have to. They have to, Kim. I'm about 50 minutes behind trying to catch up. Come on, slow bus. Yellow bus. Slow. Oh, hopefully this makes up for the false alarm of the day. It does. It does, Murph. You're forgiven. I don't believe him at all. He would have said something at the time. Yeah. But also, I'm not saying he's lying. I won't, I'm not going to say he's lying. It's just that if he did observe the way he observed, he dealt with it incorrectly. Totally incorrectly. This is a different outcome, possibly, but not even different outcome. If you see it, you tell the judge, and the judge then might just give them a 5-minute break, or hey, everyone stand up, stretch. We're not in this position. It seems to me. I don't think he was lying. I think that this person might have been sleeping a little bit, dropping off, but I think that they chose not to say anything in the moment and wait until now, which is just as bad as lying. It's just as bad. Deal with it in the moment. Don't deal with it the next day. Erin Hack, we're on a break. Run, Erin, run. It's like, what's that? Oh, run. What's that? Life's like a box of chocolates. You never know what you're gonna get. What's it called? Forrest Gump. Run, Erin. Run, Gump, run. Here he is, David. Morning, ladies. No flowers for the ladies. Only for Wendy. When he cuts his hair, we will take him seriously. There's that as well. I'm on 2.0. Happy days. Right. So we got this now. We got jury instructions first of all. Then we got thanks, Kimmy. Thank you, Kimmy. Then we got the deliberations. The way I understand it is first degree intentional homicide, second degree, and I'm not sure what the rest of it is, and manslaughter are the three, I believe, charges that they can consider. We'll know more once the judge reads the jury instructions out. There's obviously a time limit, and I'm not sure what the time limit is for closings. I didn't catch that. So there is a time limit, so it's not like Carragher trial where it was unlimited amount of time. There is a fucking time limit, thank God. So for this afternoon, I've got a Tragos video to play, and he analyzes the Miu testimony yesterday. It's a 3-hour video, which I'll play this afternoon. Then tomorrow, if they still haven't come back with a verdict, we'll have a think about tomorrow. Then Friday's a can't read hearing. I'll probably stream that, and I got Sean El Jefe. He's probably going to join me now and again. So that's why I was on the phone with El Jefe there. So if you don't know, trial for Karen Reid begins Tuesday, and I will be streaming that with Sean. He's going to be joining me throughout that trial. I believe on Tuesday is jury and picking a jury, so they might not show it. But if they're not showing it, we're still streaming anyway. So and we got some guests lined up for the stream for the trial as well. We're gonna have people pop on in and out, shake it all about, do the hokey cokey and turn around. That's what it's all about. Oh, hokey hokey hokey. Oh, hokey hokey hokey. Oh, okay, okay, okay. Dum, ba, dum, ba, dum, ba, ba. Right, 2 secs. So yeah, that's the plan. That's what I was on the phone with Sean about. He's excited. We're all excited. So yeah, it's gonna be good, hopefully, for Karen Reid. Karen Reid time, 16th of April at 9 AM Eastern, I believe. Hey, it's early. Sorry, Seahawks. Sorry. What time? Yeah, 9 o'clock, I believe. I'm not sure. On Tuesday. I thoroughly enjoyed it, and I haven't even. Thank you, Jonathan. Jobbathan. Who's Karen Reid? Jesus Christ. No, Dave. Karen Reid. Remember we covered it. And you see behind me. It's not the one that escaped. I know which one you mean. It's not that one. No, it's the one from Massachusetts. Um, she is accused of alleviating her fiance by running him over with her SUV, which I call BS on. So that's the trial from Mass. Um, Dedham, I believe the court is. So I think it's supposed to be a 6-week trial, Christine. I think the state believe it's going to be 4 weeks, and then defense said roughly 2 weeks as well. So, but anyway, that's enough of that. That's to explain why I was late on the phone with Sean El Jefe. So super excited for that. So welcome to join us if you want to. Next Tuesday, and maybe of course on Friday as well for the hearing. So back to this Kyle thing. Hold on, before I do that, Karen Reid's very similar to Zach Ranson's. Uh, Similar in some ways, maybe. I'm not sure. Snowball Trial. I'm not sure. Yeah, I'm not sure. Um, I think the main difference is a body this time. I mean, there was no body obviously for Zach, but there's a lot of circumstantial evidence, shall we say? Night Court. Was your Night Court? Was he? So again, for those following, we have got jury instructions followed by closings, which are going to be timed. So, bam, bam, ba 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 ba. I'm not sure how my audio is doing. I'm trying to hold my audio now. Jonathan. Um, yeah, yeah. Okay, if it's that, then yes. And they've both got the sign. There you go. Sorry, I wasn't sure what you meant, Kim. That's all. But indeed, then you are right, Kimmy. I wasn't sure what you meant. I was yeah. Um, I was trying to make sure my audio is down. Yeah, Jobbathan. Um, I got. Oh, where is it? Here it is. I've been spraying today. Hey Jamie, I've been spraying today. My laptop. The only problem is John. Hey Jamie, can't get the fucking things back. The screws. I can't get the screws back in. Can't get them back in the hole. Well, for two of them anyway. So I have cleaned my laptop. I can still hear it churning, but it's, I don't think it's as bad as it used to be though. But I've restarted my computer. I have cleaned the dust out of my laptop with shout out to Josie who told me to buy a air tin thing, which I have. So I'm not sure. We'll see how it goes today. We'll see how she goes. We'll see how it goes. Dave, stripped them, but makes me happy to know you cleaned it thoroughly. Yeah, well, I did. But I'm not sure if I did it thoroughly. I sprayed it. You know, covered it. I didn't see any dust, that much dust though. Uh, take my wife's laptop apart once a year and clean it. Takes a couple of hours. Couple of hours. This took me 2 minutes. I just fucking sprayed it. And it done. Hang on. Into corners. Hmm. Yeah, I can't do that though. Can I? Do you know what I mean? You're a different breed than me. Just getting the whole back of it was like hard enough. But anyway, I got most of the screws back in just to, hey, if it works without them, you don't need them in the first place. So heat sinks, yeah. Anyway, right, where are we now? We got this. We're about a minute away. We are on fire. Only desire and you. Ba-da, da, beep, bop, beep, 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 da, da, da. Ain't nothing but a heartbreak. Tell me why. Ain't nothing but a here to stay. I want it that away. Bum, 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 ba, ba. Tell me why. Ba. Sorry, I'm looking for something. Where is it gone? Da-da. I want it that away. Do, 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 do. Right, and we're back. Right, so tell me why ain't nothing but a heartbreak. Tell me why. Choreography, no, you don't want to see me choreography. Got a top off, spinning it. Way. No, you don't want that. Talking to the sleeping beauty, telling her to pay attention. Probably not. I think the judge would probably remind everybody, but probably not signal anyone out, I got to take my nice stuff apart and I'll go wash everything. At some point, the components get a little sticky from smoking weed out there. Jesus. No, 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 no. See, I get bullied on my own channel by the hackster, the mods. Jesus. Yeah, I'm not. If people don't like my singing, do one. Do one. But I can start my choreography. I mean, no one wants to see me take my top off. So, or full on dancing, flash mob. Oh, thanks, Kimmy. No, I love singing. I can't sing in tune, but I still love singing though. How is the audio, by the way? I noticed yesterday I was too far away, so I'm trying to make sure my mic is up close to my face. A lot, well, closer to my face then. I do feel like a pop artist. You are my fire, my only desire, and I bam bam bam. Judge is back. I want it that way. Judge is back.
Yeah. I'll just wait till they come in.
Judge is back. Da-da-da-da-da-da-da-da. Judge is back. Ain't nothing but a jury are on the way. Jury are
Please
on
be seated.
the way.
All right, members of the jury, good morning. We are ready to deliver the jury instructions, and then the attorneys will make their closing arguments. Here's how the day will work. I will deliver the jury instructions to you. That'll take some time. I will have them displayed up on the board so you can follow along, but I will read them aloud in case you prefer to listen. After that, Mr. Anderson will deliver the state's closing argument. We'll take about a 15-minute break, and then Mr. Trofasi will deliver Mr. Miu's closing argument, and then the state will have the opportunity for a brief rebuttal. After that, you'll begin your deliberations. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether Mr. Miu is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The state filed an information that alleges that Nicolae Miu committed crimes in St. Croix County, Wisconsin, on July 30, 2022. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against Mr. Miu in any way. It does not raise any inference of guilt. In count one of the information, Nicolae Miu is charged with first-degree intentional homicide, and you must consider whether he is guilty of that offense. If you are not satisfied that Mr. Miu is guilty of first-degree intentional homicide, you must consider whether or not he is guilty of second-degree intentional homicide, or first-degree reckless homicide, or second-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second-degree intentional homicide and first and second-degree reckless homicide are different degrees of homicide. Homicide is the taking of a life of another human being. The degree of homicide defined by law depends on the facts and the circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements that are common to each crime. Both intentional and reckless homicide require that Mr. Miu caused the death of the victim. First and second degree intentional homicide require the state to prove the additional fact that Mr. Miu acted with intent to kill. First and second degree reckless homicide require that Mr. Miu acted recklessly. First degree reckless homicide requires proof of one additional element, that the circumstances of Mr. Miu's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Miu has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force that is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. The words great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. There is no duty to retreat. However, in determining whether Mr. Miu reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether Mr. Miu had the opportunity to retreat with safety, whether such retreat was feasible, and whether Mr. Miu knew of the opportunity to retreat. You should also consider whether Mr. Miu provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against that attack. However, if the attack that follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he reasonably believes he has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. As applied to this case, the effect of the law of self-defense is Mr. Miu is not guilty of any homicide offense if he reasonably believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of second-degree intentional homicide if he caused the death of Isaac Schuman with the intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Mr. Miu is guilty of first-degree intentional homicide if he caused the death of Isaac Schuman with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of first-degree reckless homicide if he caused the death of Isaac Schuman by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. Mr. Miu is guilty of second-degree reckless homicide if he caused the death of Isaac Schuman by criminally reckless conduct. You will be asked to consider the privilege of self-defense in deciding whether the elements of first and second-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding of whether Mr. Miu acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second-degree intentional homicide or for first or second-degree reckless homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find Mr. Miu not guilty. The facts necessary to constitute each crime will now be defined to you in greater detail. First-degree intentional homicide, as defined in section 940.1 1 of the Criminal Code of Wisconsin is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that Mr. Miu did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find Mr. Miu guilty of first-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following elements were present. First, Mr. Miu caused the death of Isaac Schuman. The word cause means that Mr. Miu's act was a substantial factor in producing the death. Second, Mr. Miu acted with the intent to kill Isaac Schuman. Third, Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The words intent to kill means that Mr. Miu had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that Mr. Miu acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act. It must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Mr. Miu's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove Mr. Miu's motive in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of first-degree intentional homicide requires that Mr. Miu did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either, one, that Mr. Miu did not actually believe he was in imminent danger of death or great bodily harm, or two, that Mr. Miu did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of Mr. Miu's belief is not an issue. You are not to be concerned. I'll start over. You are to be concerned only with what Mr. Miu actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Miu is guilty of second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Miu caused Isaac Schuman's death with the intent to kill, and that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of first-degree intentional homicide, and you must consider whether he is guilty of second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether Mr. Miu is guilty of second-degree intentional homicide. Before you may find Mr. Miu guilty of second-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu caused the death of Isaac Schuman. Second, Mr. Miu acted with the intent to kill Isaac Schuman. Third, Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. One, that a reasonable person in the circumstances of Mr. Miu would not have believed that he was preventing or terminating an unlawful interference with his person. Or two, that a reasonable person in the circumstances of Mr. Miu would not have believed he was in danger of imminent death or great bodily harm. Or three, that a reasonable person in the circumstances of Mr. Miu would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Miu's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed. In Mr. Miu's position, under the circumstances that existed at the time of the alleged offense, the reasonableness of Mr. Miu's beliefs must be determined from his standpoint at the time of the acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Miu caused the death of Isaac Schuman with the intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of second-degree intentional homicide. If you are not so satisfied, you must not find Mr. Miu guilty of second-degree intentional homicide, and you should consider whether he is guilty of first-degree reckless homicide, which is also a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether Mr. Miu is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in section 940.02, parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Miu guilty of first-degree reckless homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu caused the death of Isaac Schuman. The word cause means that Mr. Miu's act was a substantial factor in producing the death. Second, Mr. Miu caused the death by criminally reckless conduct. Criminally reckless conduct means conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Miu was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether Mr. Miu's conduct created an unreasonable risk to another. If Mr. Miu was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in this case that the risk was unreasonable. The third element, the circumstances of Mr. Miu's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Miu was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Miu's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of Mr. Miu's conduct showed utter disregard for human life. Consider also Mr. Miu's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. If you are satisfied beyond a reasonable doubt that Mr. Miu caused the death of Isaac Schuman by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree reckless homicide. If you are not so satisfied, you must not find him guilty of first-degree reckless homicide, and you should consider whether he is guilty of second-degree reckless homicide, which is a lesser included offense of first-degree reckless homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether Mr. Miu is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in section 940.06 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The difference between first and second-degree reckless homicide is that first-degree offense requires proof of one additional element: that the circumstances of Mr. Miu's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree reckless homicide were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Miu guilty of second-degree reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that Mr. Miu caused the death of Isaac Schuman by criminally reckless conduct, you should find him guilty of second-degree reckless homicide. If you are not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Miu guilty of more than one of those foregoing offenses. Mr. Miu is charged with attempted first-degree intentional homicide of Alexander Martin in count 2, Dante Carlson in count 3, Anthony Carlson in count 4, and Riley Madison in count 5. For each count, you must first consider whether Mr. Miu is guilty of attempted first-degree intentional homicide. If you are not satisfied that Mr. Miu is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide or first-degree recklessly endangering safety or second-degree recklessly endangering safety, which are less serious degrees of attempted criminal homicide. The crimes referred to as attempted first and second degree intentional homicide and first and second degree recklessly endangering safety are different degrees of attempted homicide. The degree of attempted homicide defined by the law depends on the facts and the circumstances of each particular case. While the law separates attempted intentional homicides into 2 degrees, there are certain elements which are common to each crime. Both attempted first and second degree intentional homicide require that Mr. Miu intended to kill another person and Mr. Miu did acts toward the commission of that crime, which indicate unequivocally, under all of the circumstances, that he had formed that intent and would have caused the death of the intended victim except for the intervention of another person or some extraneous factor. First and second degree recklessly endangering safety requires proof that Mr. Miu recklessly endangered the safety of another human. First degree recklessly endangering safety requires proof of one additional element: that the circumstances of Mr. Miu's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Miu has committed. For count 1, you were instructed on the law of self-defense. The same self-defense standards apply to your consideration of the charges of attempted intentional homicide that are alleged in counts 2 through 5. If you find that the elements of the crime have been proved in this case, the effect of the law of self-defense is as follows. Mr. Miu is not guilty of either attempted first or second degree intentional homicide or first or second degree recklessly endangering safety if he, 1, reasonably believed that he was preventing or terminating an unlawful interference with his person, and 2, reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of attempted second-degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Mr. Miu is guilty of attempted first-degree intentional homicide if he did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of first-degree recklessly endangering safety if he recklessly endangered the safety of another human under circumstances that showed utter disregard for human life. Mr. Miu is guilty of second-degree recklessly endangering safety if he recklessly endangered the safety of another human. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether Mr. Miu acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilt for attempted first or second degree intentional homicide or first or second degree recklessly endangering safety. If the state does not satisfy you that those facts are established by evidence, you will be instructed to find Mr. Miu not guilty. The elements of each crime will now be defined to you in greater detail. Before you may find Mr. Miu guilty of attempted first-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu intended to kill the named person. For count 2, the state must prove Mr. Miu intended to kill Alexander Martin. For count 3, the state must prove that Mr. Miu intended to kill Dante Carlson. For count 4, the state must prove that Mr. Miu intended to kill Anthony Carlson. For count 5, the state must prove that Mr. Miu intended to kill Riley Madison. Intent to kill means that Mr. Miu had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. The second element, Mr. Miu did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person except for the intervention of another person or some other extraneous factor. Unequivocally means that no other interference or, Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from Mr. Miu's acts under the circumstances. Another person means anyone but Mr. Miu and may include the intended victim. An extraneous factor is something outside Mr. Miu's knowledge or control. The third element, Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. While the law requires that Mr. Miu acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Mr. Miu's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing guilt of a defendant, the state is not required to prove Mr. Miu's motive in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of attempted first-degree intentional homicide requires that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove either, 1, Mr. Miu did not actually believe he was in imminent danger of death or great bodily harm, or 2, that Mr. Miu did not actually believe the force used was necessary to prevent imminent death or, 2, that Mr. Miu did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of Mr. Miu's belief is not an issue. You are to be concerned only with what Mr. Miu actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Miu is guilty of attempted second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Miu intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson for count 3, Anthony Carlson for count 4, and Riley Madison for count 5, and that Mr. Miu's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some other extraneous factor, and that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of attempted first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted first-degree intentional homicide, and you must consider whether Mr. Miu is guilty of attempted second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether Mr. Miu is guilty of attempted second-degree intentional homicide. Before you may find Mr. Miu guilty of attempted second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present. First, Mr. Miu intended to kill the named person. Second, Mr. Miu did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person, except for the intervention of another person or some extraneous factor. Third, Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of intent to kill, unequivocally, another person, and extraneous factor. The same definitions apply to your consideration of attempted second-degree intentional homicide. The third element of attempted second-degree intentional homicide requires that Mr. Miu not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. 1, that a reasonable person in Mr. Miu's circumstances would not have believed that he was preventing or terminating an unlawful interference with his person, or 2, that a reasonable person in Mr. Miu's circumstances would not have believed he was in danger of imminent death or great bodily harm, or 3, that a reasonable person in Mr. Miu's circumstances would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Miu's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in Mr. Miu's position under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Miu's beliefs must be determined from the standpoint of Mr. Miu at the time of his acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Miu intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, Riley Madison for count 5, and that Mr. Miu's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some extraneous factor, and that Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of attempted second-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted second-degree intentional homicide, and you must consider whether Mr. Miu is guilty of first-degree recklessly endangering safety, as defined in Section 941.30 of the Criminal Code of Wisconsin, which is a lesser included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted second-degree intentional homicide before considering the offense of first-degree recklessly endangering safety. However, if after full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of attempted second-degree intentional homicide, you should consider whether Mr. Miu is guilty of first-degree recklessly endangering safety. First-degree recklessly endangering safety, as defined in Section 941.30, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Miu guilty of first-degree recklessly endangering safety, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu endangered the safety of another human being. Second, Mr. Miu endangered the safety of another by Mr. Miu endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Miu was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should also consider the evidence relating to self-defense in deciding whether Mr. Miu's conduct created an unreasonable risk to another. If Mr. Miu was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. The third element, the circumstances of Mr. Miu's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Miu was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should also consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Miu's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of Mr. Miu's conduct showed utter disregard for human life. Consider also Mr. Miu's conduct after the act alleged to have endangered safety to the extent that it helps you to decide whether or not the circumstances showed utter disregard for human life at the time the act allegedly to have endangered safety occurred. If you are satisfied beyond a reasonable doubt that Mr. Miu recklessly endangered the safety of another, those named in each count, Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, and Riley Madison count 5. And the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree recklessly endangering safety. If you are not so satisfied, you must not find him guilty of first-degree recklessly endangering safety, and you should consider whether he is guilty of second-degree recklessly endangering safety, which is a lesser included offense of first-degree recklessly endangering safety. You should make every reasonable effort to agree unanimously on the charge of first-degree recklessly endangering safety before considering the offense of second-degree recklessly endangering safety. However, if, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree recklessly endangering safety, you should consider whether Mr. Miu is guilty of second-degree recklessly endangering safety. Second-degree recklessly endangering safety, as defined in section 941.30, parent 2 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The differences between first and second-degree recklessly endangering safety is that the first-degree offense requires proof of one additional element, that the circumstances of Mr. Miu's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree recklessly endangering safety were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Miu guilty of second-degree recklessly endangering safety. In other words, if you are satisfied beyond a reasonable doubt that Mr. Miu endangered the safety of Alexander Martin, Dante Carlson, Anthony Carlson, or Riley Madison by criminally reckless conduct, you should find him guilty of second-degree recklessly endangering safety. If you are not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Miu guilty of more than one of the foregoing offenses for each count.
Sorry, Judge. Could we take a brief break, please?
Yes, please take the jury out.
All rise for the jury.
Let's return in 5 minutes, 9:40.
9:40 start. Right.
No, I started, I just wait.
Just the people asking some questions. Stan, Stretch, Sean. So, just because some people are asking, yes, David, who you might know as MLS, did get yeeted. He's losing his channel in 5 days. I posted a link for his new channel in there. Please go support him. Look, this is more than just Hales and everything. I'm so surprised because, like, this could be any content creator. Tomorrow, I could lose my channel. Anybody could lose their channels. So what happened was that Jeremy Hales did not like MLS's stream, even though he was very entitled to use Jeremy's stuff. It's fair use. We're using law and crime stuff now. It's fair use. I can do whatever I want as long as I transform it. So he got copyright struck. Copyright struck 3 times now, and he lost his channel. I'm just shocked and appalled because this could be any content creator. It doesn't matter who the fuck it's against. Like, I've not spoken to David since probably September, right? But Who gives a fuck? I don't care who you are. If you like a content creator, if you don't like them, whatever. Like, Dave's a great content creator. He's helped out a lot of people. I would say the same thing if it was, I don't know, whoever, Joe Blogs on the road. If we can't support each other, others as content creators, I got a strike before, and I shit myself because I thought I'm gonna lose my channel. It's a scary experience to lose your channel. This is my livelihood. If I lost it, I'd hope that the people in the community would actually rally around me and try and get my channel back. I can't believe I'm posting, and I'm a guy that I say I've not spoken to him since September, and no one's fucking posting anything. I just can't believe it. Like, it's nothing about Hales. It's nothing about anything. It's about content creators sticking together, making sure we do not get our channels eaten for bullshit. No one should be copyrighting stuff like that. Everyone can make their own decision if they want to support David or not. I'm not telling people they should support him, whatever. Do what you want to do, but I'm just surprised. I'm just surprised. You know, um, I don't know. So please go support him, because he's going to get back on his feet. He's going to get back on his feet very quickly because he's going to get a lot of support. He's going to get a lot of people subscribing. Please go and subscribe to him. I posted a link. I'll post it again. There's 2 links, Lego one and the God one or something. I'm not sure, but we'll post them. Go and support. The biggest problem is he's now, during the next probably few weeks, not going to be monetized. He's a content creator. Okay, it's not his full-time job, but he's still a content creator. He gets to keep his videos, great, but he's monetized. He's worked hard to be monetized. Now he's lost all that. It's not on. And this could be a small content creator. As I say, David's going to build it back up. That's not the point, though. This could be a small content creator. If I lost my channel, I've lost everything. I literally have lost everything. And to see that no one is out there supporting, it scares me because I thought as a community, we'd all get together and be like, fucking right. You don't copyright strikes, because of over some bullshit. It scares me to think no one would have my back. I'm shocked. I'm just shocked by it. Each to their own, but I can't believe it. Honestly, I'm not going to shut up because I'm not here to cause drama. People can do whatever the fuck they want, but I'm just shocked. But and to be quite honest with you, I'm a little bit worried myself now that if someone like David, as popular as David, will not get this support, how the fuck am I going to get any support? You know, it's just scary. So please go and support him. As I say, it's not about the Hales. It's not about that. I don't know anything about the Hales. I know nothing about that argument. I've not had them on my channel. People apparently are scared to say their names. Come out, if they're going to come at me, they're going to come at me. What's he going to do? I've never put his content on my channel. What's he going to do? I don't get it. Why are people so scared of this guy? Maybe I should be scared. I don't know. Maybe they know something I don't, but it, I don't know. I'm not going to rant on it too much. As I say, I don't want the drama from it. Just take David out, insert any content creator in there. You should be supporting them, in my opinion. So there you go. That's my mini little rant. So please go and subscribe to him. And yeah, we'll keep posting his links so people do know. I appreciate Kim. I know Kim and a few others said that you've just subscribed to him, so I appreciate that. Thank you. Right. And breathe. As I say, I'm only small content creator. I can't make much of a difference. There's other people out there that can make differences. So, keep pushing it. Keep pushing it. Go to creators and ask them to support. Why are they not supporting? If I'm supporting him, Jesus Christ. Anyway, as I say, there's no point me ranting, because it could cause more problems with David. I don't want to cause any issues for him whatsoever. So back to this trial. I hope my audio's good. I got to hold this now. Look at it. Do you like it? I keep kicking it. And this thing Wait, it's not worked. My laptop's still heating over. Anyway, right, Mexi Texi. Hey, Mex. How we doing, Mex? We've got another modern board now. Sorry, I'm missing chat now. Right, somebody call it. Tilly, you cannot call Erin Hack smart. She asked what this is. This is a air dust utility. So I sprayed it, but it's not work. Well, I mean, sort of work, but it's still overheating. So I'm probably gonna have to buy a new laptop, but not yet anyway. Anyway, right, we're back to it. Let's go, peeps. Let's strap yourselves in. Let's fucking go. Fuck, which one did I put on? That's the one.
I think I speak for everyone in the courtroom. That was a well-timed break. All right, is everyone ready to listen to the judge talk some more? All right. I'm picking up on page 20. In count 6 of the information, the judge alleged that Mr. Miu committed battery. Battery, as defined in section 940.19, parent 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with the intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find Mr. Miu guilty of this offense, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following 4 elements were present.
Judge, can we approach quick?
Yes?
Come on, this could be sorted way before now. Come on. That's one like me and that's one. Oh, he misspoke. Oh, the judge is laughing. He's misspoke. They're all laughing.
Every lawyer loves to tell the judge he made a mistake. I made a mistake. In count 6 of the information, the state alleged that Mr. Miu committed battery. So let me get to the elements. First, Mr. Miu caused bodily harm to Madison Cohen. The word cause means that Mr. Miu's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. Second element, Mr. Miu intended to cause bodily harm to Ms. Cohen. Intent to cause bodily harm means that Mr. Miu had the mental purpose to cause bodily harm to another human being, or was aware that his conduct was practically certain to cause bodily harm to another human being. The third element, Mr. Miu caused bodily harm without the consent of Ms. Cohen. The fourth element, Mr. Miu knew that Ms. Cohen did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from Mr. Miu's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent and knowledge. The state must prove by evidence that satisfies you beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. You were instructed on the law of self-defense in count 1. The same self-defense standards apply to your consideration of the charge of battery alleged in count 6. If you are satisfied beyond a reasonable doubt that all 4 elements of battery have been proved and that Mr. Miu did not act lawfully in self-defense, you should find him guilty. If you are not so satisfied, you must find him not guilty. The information alleges not only that Mr. Miu committed the crimes charged in counts 1 through 6, but also that he did so while using a dangerous weapon. If you find Mr. Miu guilty on any of these counts, you must answer the following question. Did Mr. Miu commit the crime while using a dangerous weapon? Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Again, great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that Mr. Miu committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that Mr. Miu is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that Mr. Miu is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with Mr. Miu's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give Mr. Miu the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give Mr. Miu the benefit of any reasonable doubt that remains after carefully considering all the evidence in this case. You are to decide the case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts, according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that Mr. Miu committed the offense before you may find him guilty. Evidence has been presented relating to Mr. Miu's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Remarks of the attorneys are not evidence. If their remarks suggested certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to the greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observation. Start over. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability, of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's age, race, national origin, religion, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. We've now reached the stage where the attorneys will deliver their closing arguments. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. First, we'll hear from Mr. Anderson. When he's done, we'll take a short break. After that, we'll hear from Mr. Sharafi, and then Mr. Anderson will be permitted to give a short rebuttal. Mr. Anderson.
Thank you, Judge. absolutely senseless and horrific acts of violence. And all Nicolae Miu had to do was walk away. All he had to do was walk away. That's what you've seen in this case. You saw he told Lieutenant Hart, "They told me I can't run away." Obviously not true. Think about the result of his actions. Everything you've seen in this trial, the horrific injuries, the death of Isaac. Why didn't he just walk away? His only explanation when testifying was, "I stood my ground. I stood my ground." First of all, Wisconsin is not a stand your ground state.
Objection. Overruled.
I'll talk about that specifically from your jury instructions. Second, that's not true, as I'll show you. He didn't just stand his ground. I'm not going to defend the actions of the boys who testified. It was cruel what they were calling Nicolae. They shouldn't have been mocking him, calling him predator, raper. But their conduct did not justify what Nicolae did. You heard from Alina, Isaac's mother, about her son Isaac. He was 17 years old when he was killed. He enjoyed golfing, spending time with friends, recently started a new business, detailing cars. He was an honor student looking forward to going to college. His death was senseless. One of the things defense said in the beginning of trial in their opening was they're glad there's a video. So are we. Without the video, Nicolae would have slipped away. The only reason he was apprehended was because law enforcement had that screenshot of him. The video doesn't fade with time. It's not biased, not influenced by alcohol. As I told you in the beginning of this case, the violent episode from the video is about 25 seconds, from the point he punches Madison until you see him walking off after stabbing 5 people. He's not seen, Nicolae is not seen in that video for 8 to 9 seconds until the point you see him walking away. You don't see him stab Dante. Some of you may have wondered why we called Marion Davis. Certainly wasn't for his eyewitness testimony, but he took a video. He took a video that captured a different angle than Juwan's video. It's grainy, it's difficult to see, but you can see enough. And it shows Nicolae seeking Dante out and stabbing him when his group is in the opposite direction. Nicolae walks into a crowd of people, stabs Dante. Before I show you that video again, I need to provide some context from Juwan's video.
Take it off.
Clear the screen, please. So here at 2 minutes and 6 seconds, this is after Nicolae has stabbed the 4 people that you do see parts of on the video. He's standing next to Ariel. Ariel's there. Nicolae's not by himself. Two minutes, 8 seconds. That's the last you'll see of Nicolae until you see him walking off in this video. You see Dante or AJ, the boys running back to their tubes, and you see Larian filming in the background. Larian captured what Nicolae was doing at this point, even though this video didn't. And here, in a moment, you can see the edge of Dante's swim trunks on the right. You can see the light on top, the dark on bottom. At this point in Larian's video, Dante's just been stabbed. Next, you see of Nicolae, he's walking off. You can see Dante in the background, holding his stomach, looking down at his wound. Well, actually, you can keep it up for a second, sorry. And then for further context, you see Alex Bang running to Isaac. Let's see Larian's video. Okay, that was me. Remember, Nicolae admitted he walked up to Larian. He walked up to Dante and stabbed him. He admitted Dante was the last person he stabbed. Here you can see Nicolae, dark swim trunks, bigger build. On the right, you can see Dante, swim trunks, lighter on top, darker on bottom. You'll see Nicolae walk up to Dante and stab him in the chest. You'll see Dante recoil from the stab. You see the boys on the right running to their tubes. And in the second here, you'll see Alex Bang. You'll zoom in on him as he runs to Isaac. I'm going to show that again. So, a few things to note. There's nothing between Nicolae and Larian. He's not surrounded. His friend Ariel is there at this point. There's nothing to the left and behind Nicolae, except his group in the distance that you can't see on video. He walks away from those directions towards a group of people and stabs Dante in the chest, not standing his ground. He's seeking out Dante. That's retribution, not self-defense. And recall too the DNA results. Isaac's DNA and Dante's DNA was the only DNA on the knife. They're also the last two that are stabbed. It makes sense from how the analyst described DNA and how it can wash off. You probably noticed throughout this trial, not a lot of witnesses come off looking great after they testify. There's some exceptions. Obviously, the Good Samaritans who went to aid Isaac and AJ. Eric Von Williams included in that from Nicolae's group. He's the only one who went to their aid. Sheena Lowell, you heard her testify from the Carlson group. You saw her just standing in the background watching what was going on the whole time. She was completely sober. You heard her testify, Nicolae punched Madison. She has zero connection with the group anymore, zero contact. Her and Quentin broke up. Tony is another one. He only comes in to break up what he thinks is a fist fight. He's directing Nicolae towards Nicolae's group. Nicolae turns and stabs him twice. Another one I submit to is an exception that acted admirably is Isaac. His death was tragic and horrific. This is what you see of Isaac in the video. On the left, he's standing next to his tube, not moving away from his tube. He's pointing at Nicolae to leave. In the middle, when Nicolae turns back to Isaac, Isaac puts his hands up, fingers splayed. The only other thing you see of Isaac is him standing in the background. When the other boys are mocking, calling names to Nicolae, Isaac is just standing in the background. He's not saying anything. He's not doing anything. He's not jeering. He's just standing there holding their tubes. There's been a pretty serious mischaracterization of Isaac's actions with regard to when he gets stabbed. Defense has tried to clarify it classify it as a strangulation. Defense accused the state in openings of being selective in the photos we used, the frames, to try to show a certain narrative about Nicolae smiling. As you've seen, he's smiling a lot in the video. But defense is actually doing that when it comes to Isaac. Nicolae never said anything about being choked, never said anything about pain on his neck, even when specifically asked by the start nurse, never mentions anything. And the video doesn't lie. So on the left, Nicolae has just stabbed Riley, who you heard from multiple witnesses were just standing there. Tony comes to try to break it up. Nicolae stabs him twice. Isaac, just off frame, I submit to you, he just saw Nicolae stab those two people completely unprovoked. Although he was in the background the whole time, not doing anything, he came to their aid. And he pushes Nicolae. You can clearly see it's a push. He has one hand on the arm, other hand on the chest. It's Nicolae's own action of thrusting the knife into Isaac's heart that moves Isaac's hands. You can even see from the release, it's a push. He's not sitting there left holding his hands out in a choking motion. Let me take the screen down.
Yes.
I'm going to show you the video so you can see it's obviously a push. While my computer is loading here, even if it was a strangulation, which it clearly isn't, Isaac was justified in using any level of force. He just saw Nicolae stab two people who posed no threat to Nicolae. Tony was breaking up the fight. He had actually ignored Nicolae at first, walked past him, pushed Dante out of the way. Riley was just standing there. Met 2 minutes and 3 seconds. Can we have the screen? Clearly a push. Defense has mischaracterized the entire situation as 13-on-1, 13-on-1, implying it's some sort of mob beating up Nicolae. It's not even 13 people yelling at Nicolae. As you saw in the video, Gabby, Janelle, they're just standing in the background. Isaac, he's just standing in the background, not yelling anything. It's 13 people in the proximity, only 2 close to him, 2 tiny females. Nicolae's clearly not afraid of the boys. He ran up on the boys, turns his back on them and others multiple times. Even at worst, this is a 2-on-1 with AJ and Dante. But even then, as you saw in the video, Ariel's right there. It's more like a 2-on-2. Ariel's right there. Plus, Tony comes in as a neutral party to separate things. It's not 13-on-1. As soon as AJ gets disemboweled, you see people start to move away. So there's not even 13 people immediately around. You saw Owen way in the background because he saw the knife. So why try to mischaracterize the situation? Because there's some things that are hard to explain otherwise for defense. Turn on the screen, please. This is the second time you saw in the video that Nicolae turns his back on boys and people from the Carlson group. You don't turn your back on somebody. It's common sense. You don't check your common sense at the door when you serve as a jury. Don't turn your back on somebody if you're afraid of them, especially if you're so afraid you got to reach for your knife. You can't be that afraid that he's got to reach for his knife and so unafraid that he turns his back on them. He was angry, not afraid. That image on the right is only less than 30 seconds after he turns his back on them, touching his knife. The defense tried to explain that change from in that 30-second window by saying he was getting pushed by Madison and Riley. He was getting pushed. They're lightly touching his arms and they're tiny. They're not in his face. You can see in the images, they're standing close. They're not in his face. They're not shaking their fists at him. They're not even sticking their fingers in his face. They're standing close to him, touching his shoulders, pointing, yelling at him to leave. I'm going to back up a little bit and talk about Nicolae looking for the phone. So Eric Von Williams from Nicolae's group, you heard testify, before any of this happened, he was concerned about Nicolae's behavior. He was concerned that people were going to think he was a predator. Ernesto told Nicolae not to go look for the phone. Others in the group told him not to. You heard they didn't care about the phone. Ariel didn't care about the phone. Nicolae went. Sandy said he went twice, was back for 5 to 10 minutes, then went again over by the boys. Defense argued in opening that the boys' goal, their goal was to humiliate Nicolae. Clearly, he wasn't looking for little girls. But the boys are not completely unreasonable in their belief. Eric Von Williams thought the same thing. They reacted wrong, but they just didn't invent this whole thing in order to humiliate Nicolae. What about Nicolae? 52 years old, apparently sober, according to, I think, what defense will argue. He didn't have any signs of intoxication when law enforcement made contact with him, but he certainly made a point of telling Lieutenant Hart multiple times how much he was losing, drinking on the river. He can't let it go that he was insulted. So much so that as the boys are tubing away from him, all Nicolae has to do is stand there. He doesn't even have to take a step back. He just has to stand there, let the boys continue tubing. They're down in their tubes. He starts walking up to them, touches his knife, and then runs up to them. You heard Nicolae's ridiculous description or explanation for why he ran up on the boys. Because one was holding a phone, he thought it was Ariel's phone. You also heard Nicolae had to concede, had to admit that pretty much everyone on the river had those phone cases. Another double standard from defense is physical attributes of those involved. They wanted to elicit evidence that Nicolae is feeble. Sandy, he wasn't feeble according to Sandy. He had a surgery a couple years ago, recovered in a few weeks. Maybe things took him a little longer than they did before. He wasn't feeble according to Ernesto. You heard Ernesto, when he was being asked about the stabbing, said, he's a big guy, he was in the army, he doesn't need a knife to defend himself. He didn't say, oh, he's this fragile old guy. He's clearly not feeble, as you see in the video. He runs up on these boys in the water. He leaves behind devastating, devastating injuries. Slices clean through 2 of Isaac's ribs. He comes out of the whole event essentially uninjured. While defense tries to argue that Nicolae is this feeble old man, they ignore that the only 2 people actually standing close to Nicolae are these 2 females that are barely over 100 pounds. If the boys are a threat, why does Nicolae run up on them? And clearly he knows they're not a threat to him. When he ran up on them, grabbed their tubes, standing over them, they did nothing. They didn't kick up at him, they didn't punch at him, they jumped out of their tubes and moved away from him. He knows they're not a threat to him. They're mocking, saying cruel things, but not violent. You saw how awkward it was for Nicolae to try to explain this transition from 0 fear to 10 out of 10 fear. He's got to take out his knife. Try to explain it with what I submit to you is obviously rehearsed testimony about his scales of fear. You heard from witnesses recounting what they recall of Nicolae, the demonic look on his face, staring through people, smirking. Defense argued an opening. It's a slide tour here, there. You know, after seeing the video so many times, that's not the case. When he's not glaring, he's smirking in the video. Recall, I asked Ernesto, his best friend, when he was trying to describe the shock of Nicolae, asked, was he smiling? He didn't say, yeah, he smiles when he's scared. He smiles when he's nervous. He said, who's going to smile in a situation where they're in shock or in fear? Nicolae was angry. He wasn't afraid. He's smirking even as he's holding the knife. Why didn't he just walk away? Defense had tried to argue there's rocks unstable, his sandals were bad, didn't stop him from running up to the boys as they're tubing away from him. Why didn't he just hold the knife up? Say, hey, I got a knife, back up. You saw, Owen is the only person who saw the knife and you saw his reaction. So everyone else was moving forward and responded to Nicolae punching Madison. Owen's trying to pull people back. Next you see him, he's off in the distance. This whole thing would have ended if Nicolae just held up the knife. Instead of opening it down by his waist without looking down, because it's human nature, if he would have looked down, people would have looked down. He holds it down by his waist, opens it up, never displays it, or says he has a knife. Nicolae did not act as any reasonable person would in that situation if they were truly in fear of their life or great bodily harm. So let's talk. Here's Owen reacting, as you see. Again, Isaac just standing in the background in the middle. You see when other people are moving forward, Owen's trying to pull them back. You heard him yell, bro, he's got a knife. So let's talk about the punch to Madison. I submit to you the evidence shows clearly, beyond a reasonable doubt, Nicolae punched her. She fell backwards, but caught herself. Multiple witnesses testified to seeing her falling backwards. Defense is saying, arguing on cross, well, she's not wet. She didn't actually fall down. If witnesses are all standing in that kind of semicircle around Nicolae, she gets punched and falls backwards, and then their attention's back to Nicolae as Dante's hitting him. They're not going to see that she caught herself. They're going to think she fell down. Look at her position next to Riley. They're shoulder to shoulder in front of Nicolae before the camera pans away. When the camera pans back, now Dante's shoulder to shoulder with Riley, and Maddie is back. She clearly got knocked backwards. Her sunglasses aren't on her head anymore. Defense has a double standard about that too. If there's not a photo of it, it didn't happen. There's not a photo of an injury, it didn't happen. We know Nicolae got punched. He didn't have any injury. Defense can't have it both ways. So turn and talk a little bit about memory, credibility. Obviously, a witness's memory is better closer to the event. That's obvious. Alcohol is going to affect memory. Traumatic events can affect memory. How fast it happens is going to affect memory. But crucially, and absolutely crucially, there's a huge difference between getting some details wrong, right hand, left hand, sequence of events, and making up an entire story like Nicolae did. Defense has tried to highlight throughout the trial, Nicolae was in this traumatic experience, give him a break. It's understandable, he made up all these lies, told this whole story. Even though he looks calm and collected in the videos, He's convincing in the videos, talking to the sheriff, talking to Lieutenant Hart. But don't give any sort of credence to the theory that trauma affects memory for anyone in the Carlson's group, any of the boys, any who were stabbed, any who had to drag Isaac as he's bleeding to death to the shore. AJ, who was disemboweled, don't give any credence that trauma might affect their memory and how accurately they can remember all the details. But Nicolae, who invented an entire story, tried to skip through the crowd. Give him credence for that. You saw what happened to all these witnesses, how fast it happened. It's not surprising, some of the details are wrong. But the major point is accurate, is consistent. This all started when Nicolae punched Madison, whether it was the right hand or left hand. You heard the turmoil of the boys when they realized Isaac is stabbed. Clearly a traumatic experience. There's a big difference between details and invention. Think about the most basic example. You and say your partner go to the grocery store, park your car, leaving the grocery store. You think your car's parked over there. They think it's parked over here. You still know the car is parked in the parking lot, even if you can't remember where it's parked. Same is true for the punch to Madison. You heard from 10 people, both from the Carlson group and the boys group, that Nicolae struck Madison. So let's talk a little bit about witnesses from Nicolae's group. Ariel, what did he say? At trial, he says Nick defended himself. Can't really say how. Never said that when interviewed with law enforcement. He denied even being close to Nicolae. Remember, Ariel was there when he stabbed Dante. He was right there when Nicolae stabbed Riley, Tony, and Isaac. Law enforcement went there with the frame of Ariel standing next to Nicolae when Nicolae has the bloody knife. Ariel denies seeing anything to law enforcement of what Nicolae did. Ernesto, at trial, testified he didn't see Nicolae get hit, just saw him down in the water. Said he couldn't remember Nicolae saying, "They took my knife." You saw on the body cam, he said that repeatedly. He testified that somebody was walking towards him, he pointed at him, "Get back." Never said that to law enforcement, although he did describe to law enforcement, as you saw, him saying, "Nicolae, get out," Nicolae walking out, and then he said, and that's it. Never said anything about anyone pointing at him and walking towards him. When I asked, he said, I wasn't asked that question. But he described that event. He also wasn't asked more than 10 times if Nicolae said they took my knife. So, about the punch to Madison again. Sergio, he's in Nicolae's group. He had walked out a little ways. You can see him in the photo on the left, in the top right. He had the white shirt, white bucket hat. He testified he saw the blonde girl in the black leotard walk over to Nicolae and say, "Go, go, go." He said it repeatedly to law enforcement. And he said Nicolae pushed her. So this is what it would have looked like from his perspective, although a lot farther back in that photo on the right. How could he have seen Nicolae do anything to Madison unless she got pushed back, punched back, something violent, not some light push? He's not going to see that from where he was. Madison testified, and you saw in the video, after she was hit, she goes back to her group. Why would she walk away back to her group if Nicolae just lightly maybe touched her, maybe didn't? She told Quentin she was punched. She told police at the scene she was punched. She told police in the interview she was punched. She testified about feeling the throbbing pain in her cheek. her heartbeat in her cheek. Maddie testified, she was told by law enforcement, sheriff's office, they didn't need the photo. You heard about that misunderstanding. She had anxiety about deleting the photo. In an effort to console her, she was told, don't worry about it. This is an important jury instruction in your jury instructions. Although we're not a stand your ground state, there's also not a duty to retreat. But in determining whether Nicolae's actions, whether his use of force was reasonable to prevent or terminate the interference, you may consider whether he had the opportunity to retreat with safety, whether such retreat was feasible, and whether he knew of the opportunity. He turned his back on them multiple times facing open water. People were yelling at him to leave, to walk away, to go. And he didn't. Instead, he took out his knife. That is not reasonable. You heard from Sheena Lowell, Janelle Duxbury, Ghazi Khazri and Nazimpour, Dante Carlson, and AJ about the strike to Madison. You heard from the boys, Ryan Nelson, Juwan Cockfield, Landon Wire, and Alex Bang. Alex Bang originally described it as slap. You heard from Owen that he heard an impact and saw Madison fall back and catch herself. Defense has to argue that they're all either lying or mistaken. All these witnesses, including Sergio. If they're lying, why would witness say I saw some swelling and some slight redness, but didn't see the punch? Why wouldn't he just say, yeah, I saw the punch too? Why wouldn't Tony say he saw the punch? Why wouldn't Tony say he saw Riley get stabbed and she's just standing there? They tried to explain what happened as best they could remember. The punch isn't on video, but you see the reaction. You hear Dante yell, you can't hit a woman before Riley is stabbed. They obviously didn't plan this lie in the chaos of the moment. So the only thing defense can argue is they're mistaken. That all of these people standing around Nicolae in that half circle, proximate shape, they're all looking in that direction, including Sergio, including Sheena, who was by the group, the tubes for the crossing group. They all were wrong in what they saw. Another defense double standard, it's relatively minor, but I submit to you it shows that they're grasping at straws, is this trying to put Nicolae's group in a different category. There's drunks on the Apple River, then there's Nicolae's group. About half of you raised your hand that you've been on the Apple River. That's what people do on the Apple River. They go up, they tube, and they drink. Nicolae was in the exact same boat they were in. He wasn't bird watching and this group of drunk teenagers ran up on him. He knew what it's about. He'd been on the river before. Another thing about the punch to Madison. You heard that they didn't get to see the video before giving their statements. Even Jawan, who took the video, said he got far enough to get the screenshot of Nicolae, and then law enforcement took his phone. He didn't get to see the video. You saw what happens in this case if somebody lies about something that happened on video, because Nicolae got burned by that. He made up complete and total lies. Video showed he wasn't telling the truth. The video happens to not show the punch, but it still corroborates what all those witnesses said. So count 6 is battery to Madison Coleman. It has 4 elements. Nicolae caused the battery to Maddie, caused the injury, the harm, the pain. She testified to that. He intended to cause the harm despite his denial. I submit to you that's clear. Don't punch somebody without intending to cause harm. She didn't consent. She testified to that. He knew she didn't consent. She's a stranger. Obviously, she didn't consent. He knew that. Punching Madison was not self-defense. Again, there's no duty to retreat, but you have to consider the opportunity to retreat, knowledge of the opportunity to retreat, and whether the use of force was necessary in preventing the unlawful or the interference in Nicolae's person. So what is the interference at the time he punches Madison? The boys are saying cruel things to him. Maddie and Riley are standing in front of him, lightly touching his shoulders. People are pointing and laughing at the boys. They're not, Maddie and Riley aren't in his face. They're standing close, but they're not in his face. What amount of force was necessary to prevent that interference? People yelling at him, Maddie and Riley standing close. What amount of force was necessary? Absolutely zero. Just walk away. That's what people are yelling at him to do. Just walk away. Instead, he takes out his knife and punches Madison. Regardless of whether you were convinced beyond a reasonable doubt it was a punch, Nicolae essentially admitted to pushing her. Sergio said it was a push, although when asked, he couldn't remember if it was a push or a punch. There's still provocation. The jury instructs them to talk about provocation and how that affects self-defense. Person may not use or threaten force intended or likely to cause death unless he or she reasonably believes he or she has exhausted every other reasonable means to escape or otherwise avoid death or great bodily harm. Remember, Nicolae ran up on these boys who were tubing away. They didn't run up on him. He ran up on them as they're tubing away from him because they insulted him. He was angry. He didn't walk away from the boys to leave the situation. He went over to Maddie, who was yelling at him to leave, and he lies to her and says, "They took my snorkel." I'm going to play that for you so you can hear it. All right, this is at 105 in the video. I'm ready.
Go, kids, go! Go! Go, kids, go! Go! Go, kids, go! Go! Doesn't matter.
You didn't. You can take it down. He didn't go over there to extricate himself from the situation. He went over there and accused the boys of taking the snorkel, which was a lie. And he had just ran up on the boys. So after he runs up on the boys as they're tubing away, he goes and tells Maddie, "They took my snorkel." He's standing there smirking at people, takes out his knife, either punches or pushes Maddie. That's provocation. Defense has zero reasonable argument, especially when it comes to Tony, Riley, Isaac, and Dante. Nicolae gets punched. He gets struck with an open hand twice. He gets ineffectually pushed by AJ. It doesn't do anything. Nicolae pops right up and disembowels AJ. After Nicolae goes down in the water, nobody approaches him. Nobody. Nobody goes to kick him. Nobody goes to punch him. Nobody goes to push him again. Tony, with Nicolae down on the ground, Tony walks by Nicolae with his back to Nicolae, yelling, "Get back to Dante." He turns around to tell Nicolae to get away, and Nicolae turns around and stabs him. Nicolae was facing his group with an open path of escape after provoking a reaction. He just stabbed Riley before stabbing Tony. After stabbing those two, he stabs Isaac. After that, after Ariel's there, he walks over to Dante, stabs Dante in the chest, right below his ribs, right below his heart. So self-defense. I submit to you, the state has proven beyond a reasonable doubt this was not justified self-defense, and Nicolae knew it. He knew it from the moment he did it. First of all, imminent threat of death or great bodily harm. He's not in an alley with no way out, with people blocking his exit. He's on an open river, 150 feet wide, people yelling at him to get away. None of them are armed. Punch, 2 open hand strikes, ineffectual push. Look at the definition of great bodily harm, whether he reasonably believed death or great bodily harm is imminent. For attempted first-degree homicide for Dante, AJ, Tony, and Riley, the state has to prove that he intended to kill each of them. And the acts demonstrate unequivocally, under all circumstances, that he had formed the intent and would have caused the death of each of them, except for the intervention of some other person and an extraneous factor. Third, the defendant not actually believed that the force used was necessary to prevent death, imminent death or great bodily harm. So for the intent to kill, but for outside circumstances. AJ, it's beyond clear. He would have died but for the blood in the helicopter. He would have died, but not for the surgery Dr. Miu performed. He is lucky, extremely lucky to be alive. What else was Nicolae's intent but to kill when he slices him up like that? He had the knife blade up. That wasn't an accident. He did not know. The first thing he does with it is slice up AJ's stomach. Riley, he slashes across the ribs. You saw the horrific nature of those wounds. He cut into her stomach, cut into her diaphragm. Luckily, he didn't hit any major arteries for her heart or lung. Tony blocked one stab, so Nicolae stabbed him again. When he blocked, he saw the injury. It was very close to where AJ's artery was severed. Dante was stabbed again, just below his heart. But for Nicolae missing vital organs, up for medical intervention. Miu claimed he had tunnel vision. Oh, sorry, back up. So Dr. Miu also testified, you heard about anytime there's a puncture wound in the torso, stomach, they have to go in because there's so many major veins, arteries, organs, they have to go in to make sure something major isn't done. Nicolae killed Isaac, almost killed AJ. Riley needed emergency surgery. Luckily, but for dumb luck, missed the vital organs of Dante. But for AJ blocking one strike, missing vital organs, he survived. Nicolae said he had tunnel vision. I thought everyone close to me was attacking me. I thought anyone touched me was attacking me. He didn't stab Ariel, and Ariel came up. Makes the tunnel vision claim a little bit unconvincing. For first-degree intentional homicide of Isaac Schuman, Nicolae stabbed him so hard, he cut clean through 2 ribs. The wound was deeper than it was wide. He sliced Isaac's heart. There's no other intent when you stab somebody directly in the heart than to kill. An intent to kill doesn't need to be planned ahead of time. Your jury instructions talk about that. It doesn't have to be formed a week, a month, a day, even a minute in advance. As long as he had that intent when he does the act, that's intentional homicide. The first element is he caused Isaac's death. That's obvious. Acted with intent to kill. I've addressed that. Did not actually believe the force was necessary to prevent imminent death or great bodily harm. I'm going to get to that in a little bit for all the counts. Third element, he did not reasonably believe the force was necessary. That also goes to, I'm sorry, that's part of the third element. So how do we know, what Nicolae believed? What a reasonable person would believe. That there's only one person on the planet who experienced what Nicolae experienced, saw what he saw, was standing in his place. And what did Nicolae believe? He believed it was unjustified. The very first thing he does is walk away, doesn't run, doesn't tell Ariel or Nestle anything, doesn't tell them to run. He walks away from his group to the other side of the river, at some point rinses the knife because it wasn't covered in blood, throws the knife onto the bank before walking back to his group, says nothing to his group other than they took my knife, puts on his hat, sunglasses, and shirt, and sits down in his team. He's the one, as he said in his interview, who says, let's go, let's get out of here. They can't right away because Eric isn't there. You saw, and as they're tubing down the river, you saw the video of him casually paddling along. You saw, so plan one, get away, slink away with the crowd. That didn't work. Plan two, play down. Can you take the screen down, please?
Camera recording started.
Still doing all right? Okay.
What's going
Temperature? Temperature's okay in here? Okay.
Somebody, I hear somebody got stabbed, and I fit the description.
Yes, you do.
All right.
Yep. So we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around,
Okay. All right.
and I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah, yeah.
Okay. All right.
So I don't know. Okay, well,
Did you see anybody injured?
no,
You didn't see anybody injured?
No.
Did you see anybody fighting?
I heard people screaming at each other. Yes.
Okay.
Yeah.
Screaming in anger or screaming in pain? Do you know?
Everybody's drunk, so I don't know. I can't tell the difference, but I would say, I don't know, just screaming.
Okay.
You know, yeah, calling each other names. But, you know, that's seen that all day. And we all been drinking a lot. I'm sure they're drunk. I'm sure they're doing, I don't know, kids being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Sure, they're drunk, kids being kids. That's what he told Sheriff Hughes, and he's acting like he has no idea what's going on. Clearly not in shock. You take it downside. Clearly not in shock. Clearly Nicolae knows that was not justified, and he's looking out for Nicolae. Slinking away didn't work. Plain dumb didn't work. He's told he's under arrest for homicide. Plan 3. Completely lie about what happened as to justify him using lethal force. The boys pulled out the knives. They twisted their arm, poked him. That's what he used, poke, with their own knife. So first degree intentional homicide and second degree intentional homicide are very similar. For first degree, did Nicolae actually believe? Did he actually believe that he was not justified? For second degree, it's the reasonable person standard. I submit to you, it doesn't make a difference in this case. It's crystal clear. He knew he wasn't justified. He knew he wasn't justified. It's crystal clear from his actions after the fact. Can't be explained away by shock. He's clearly not in shock. The use of force on AJ, stabbing Riley just standing there, stabbing Tony trying to break it up, stabbing Isaac directly in the heart. Ariel's there, walking up to Dante and stabbing him. The injuries he left behind, that all shows his intent. Again, you have to consider whether he knew he could retreat, whether there was a safe escape. He could have just walked away. He could have just raised his knife. He didn't do any of that. He just stood there with the knife until he punched Madison. He touched his knife when running up on the before running up on the boys. He takes out the knife, opens the blade up, never says anything, never walks away, never takes a step back, never raises the knife, never yells for help. He's smirking with the knife in his hand. Finally, after stabbing 5 people, then he walks away. Doesn't run, walks. It's shocking to see what Nicolae did in this case, to see the injuries, and then see his calm, cool demeanor after the fact, tubing down the river, sitting in his tube at the scene in chaos, casually talking to Sheriff Knudsen, making up this huge lie to Lieutenant Hart. He even lied to the start nurse at 9 p.m., so 5 hours after the incident, about boy pulling a knife, twisting his arm, poking him with his own knife. He even lied to Sandy after the arrest. Nick recognizes that what happened is not justified self-defense. Just standing there with the knife, not walking away when he clearly can. So even to Sandy, after he's charged, he casts blame on her and the group for not hearing him yelling. He never yelled. Normally, it'd be difficult to know what a defendant believed in a self-defense case, not in this case. Nicolae was not in fear, he snapped. He was angry and he snapped, and he knew it. His actions show he knew he did not reasonably believe the amount of force was necessary. He was not actually in fear. If he was actually in fear, he would have left. How else? What other clues? Think about his testimony. We submit to you that this is first-degree intentional homicide and first-degree attempted homicide. His acts clearly show intent. If you can't agree unanimously on that, as your jury instructions tell you, you have to consider second degree. Again, the difference in second degree is Nicolae's belief versus reasonable person. You know, I submit to you his belief from his own conduct. Afterwards, he knew it was not justified. If you can't agree on second degree, you consider first degree reckless homicide, first degree reckless endanger of safety. Element 1, Nicolae endangered the safety of another human being. That's obvious. Endangered the safety of another by criminally reckless conduct. The jury instructions define criminally reckless conduct, creating a risk of death or great bodily harm. It's unreasonable and substantial. He was aware of the risk. Again, obvious when he's stabbing people. When you talk about reckless conduct, let's say you believe his testimony that he just thought anyone touching him, anyone close to him was attacking him and stabbing him. That's reckless. That's criminally reckless conduct. That's utter disregard for human life. What other clues are there out to disregard? He just walks away. He doesn't call 911. He just sits on his tube as other people are helping the victims. He tubes down the river. Your jury instructions talk about the question, the special question, yes or no. Did he commit these crimes while possessing a dangerous weapon, a pocket knife? There's nothing inherently wrong with carrying a pocket knife. A lot of people carry pocket knives. Totally fine to carry it as a tool, totally fine to carry it for self-defense, totally fine to carry any legal weapon, firearm, knife, if it's used legally. Nicolae he was not justified in self-defense when he attacked these people. So we ask that you answer yes on that question. In the end, what is beyond clear, Nicolae he knew this was not self-defense. All of his actions, from the minute the stabbings are done, from the second the stabbings are done, he knew it. It's obvious. His actions were horrific. They were senseless. He killed Isaac Schuman, stabbed him directly in the heart, disemboweled AJ, stabbed Tony who's trying to break up a fight, Riley who's just standing there, and then walks up to Dante. That walking up to Dante, stabbing him when he's got clear paths to retreat, that destroys any argument that this was self-defense. He was angry. There's no rational reason Nicolae, his group's over here, would walk this way towards the group of people to stab Dante. Senseless and horrific acts. The state has to find Nicolae Miu guilty of all charges. Thank you.
Thank you. We will take a 10-minute recess. We'll be reconvening at 11:05. Please take the jury out.
All rise for the jury.
$11:05.
So that was what? I'm speaking. Thank you. That was 56 minutes long. So I'm not sure if they've been given like 90 minutes or something each. I might have missed that, but yeah, that was 56 minutes long. It felt longer. I don't know why, but that felt a lot longer than 56 minutes. Oh, thank you, Chrissy. I think he should have only requested an attorney, nothing more than that. Yeah, I think it's a different scenario if you requested it. Well, so what do you think? So I've always been staunch not guilty on the first degree, but now all the other things have come through. It's a tough one now. You know, but it's interesting, right? It's interesting. Let's have a chat here. It's something that Merv Turf said the other day, right? And I hadn't thought about this, and I know I'm not sure where Merv got it from, if she thought this herself or if she got it from Branca or somebody, but the main thing here is the first question is, was it self-defense or no? That's what you gotta ask. Was it self-defense? Yes or no? Depending on what you think then about that, you know, in some ways you don't look at the charges until you think, right, was that self-defense or not? And then you'll go and go through the charges. Even if he wasn't self-defense, I still don't think the intentional ones. I would be looking at the reckless ones, first degree reckless homicide, second degree reckless homicide, if I believed it was not self-defense. Obviously, I'm the guy with the mic, so people get pissed off with me when I start speaking because they're like, "Motherfucker, I disagree with you. Fuck off!" Like I think we've all got different perspectives of this trial. For me, what I've learned, and I've listened to Branca, actually listened to Sean, listened to all of you guys back and forward. I think I've said from the start that I believe that it was self-defense, right? So this is my thought process. I don't think he should have approached them or touched the tubes or the tubes, as Sean says about Aaron Hack. Tubes. He touched the tubes. So that was the first engagement. Now listen to Branca. Branca said that as long as he turns around and walks away, then that's disengaged. He's then disengaged from that situation. So how I cope in my head then is that no longer exists. That's happened. That's put to the side. That's no longer a part of this because he walked away. I remember when we first watched the video, I said to everyone, "But let's play it again and again and again and again and again." Because the first thing I noticed was that as he was walking away, he was going knee deep into the water. And my thought process there, and it hasn't changed, is that he could no longer further go down that route because he was going into deeper water. So he had to turn around. And that's where the second engagement happens. This is where people will agree or disagree. And I think this is the crux of it. So he's going towards his friends and family, and the group, two sides join him, meet him there. Now, I know and I appreciate some people will say, well, he may have engaged differently. I think that's the crux of it. For me, I think that they came to him, not the other way around. I know there's a horseshoe shape around him, and people will say that he could have gone back, and I appreciate that. I know some people have that belief, and he could have walked away. I personally don't think he could have walked away because I think you're going away from your safety, from the family and friends. You're going into danger, or more danger, going deeper down the water. And the first engagement then was obviously the girl put her hands, or the woman put her hands on him. We don't know the punch, the slap, and everything like that. I think his story, in my opinion, is more believable than the punch. I don't believe you can have it both ways. If you think this guy is a scary monster and he's like 250 pounds, 6'2", he's Hulk Hogan or whatever, then if he's punching that woman, she's on her ass on the floor, and she's not. She stands there. Her face goes, but she stands there. So I do believe there's a slap. If anything, a slap at most. I don't think it was a punch. I think if it was a punch, she would have landed on her ass on the floor. Now, whether you believe that's justified or not, that's up to you. That's your prerogative. You know what I mean? I'm not gonna tell anybody how to believe. As I say, I don't think there's a you know I think it's so close. I don't think there's a slam dunk yes, slam dunk no here. I'm a no. I think it's a not guilty, but I fully respect people that think that it's guilty because it's how you think. It's how we all think differently. In my opinion, I've never been in that situation, so I cannot say how I would react in that position. And I know some people say they would have walked away. They would have, um, been able to talk their way out of it. They would have done loads of different things. I get it, but he didn't do that, and I don't know how I would. Um, I don't know how I would have reacted. I don't know. I literally don't know how I would have reacted. So, you know, I think it's one of those things that you can put yourself there, you can guess, but you got to go by the video. So she pushed him, she touched him, hands on him. So essentially that is force. Like again, going back to what Branca says, that is the first engagement. Now I'm not using Branca because he's an expert in this. He's a self-defense lawyer. He's an expert. So I'm using what I've learned from him. Now, if I was a juror, I'm not sure what I'd be thinking because I wouldn't have this knowledge that Branca's given me. So I've got to think like that as well. I don't know. But as I say, I go back to when I first watched the video. I was scared for him in that moment. I was scared for him. I mean, they're 17, they are big guys, so it's very unfortunate. Again, I go back to I do not believe that anybody comes out of this looking good. it's such an unfortunate situation, and I don't think there's a right or wrong here in terms of anything. I can see why people think he's guilty, but I also can see why people think that he's not guilty. See you, Tilly. Lovely to see you. Thank you for that. What I will say about this case is, as I say, I'm not guilty. I think that it was self-defense at the end. When I play it all the way through, milliseconds there, I don't know, but there's a lot of people in the chat that I respect and have him as guilty, and like there's some people also that is guilty no matter what, but there are people in chat that have given really good arguments of why they believe he's guilty. So the people here that I really respect that say he's guilty. So I don't think this is slam dunk. I think it's, you know, you can look at it either way. So they're very smart people here on both sides, and some people still probably in the middle, not knowing how they would go. So I say just because I think I lean more towards not guilty, um, based on what Murph said. Is this self-defense or not? Without looking at the charges, is this self-defense or not? And I believe that he could have been in a panic, surrounded by 13 people. Again, I'm not going to judge him because I've never been in that situation. I don't know how I would have reacted. I generally don't know how. I'm a big guy, but having 13 people around you, no, I know. But yeah, that's my thoughts on it. That's where I sit on it. Obviously, if he was guilty, again, I don't see you can do the intentional. I think reckless fits in there. Um, yeah, I'm proud. I think apart from a couple of times, I think most people have um been able to agree to disagree on this one. I love this. I think it might come back as hung because there's so much division that I wouldn't be surprised. Or do they, I mean, I'm just speaking off the cuff now. If I'm going through the evidence again, listening to people, maybe, people can be persuaded into like first degree or second degree reckless. Because it could be reckless, but as I say, I'm looking at this from a self-defense point of view. I think it might be hung to. Intent is not premeditation, so it should be second degree anything. Yeah, that's again. I'll see. I respect you. This is, you speak sense. It's fine. As I say, we all will look at this slightly differently. I don't disagree with you. I'll see. Reasonable doubt abounds. That's why I hear that. Yeah, I think so. Yeah, because remember, it has to be beyond the reasonable doubt. I still struggle with this one. I didn't think I would struggle with this one. I didn't, but because I thought I would find him guilty for second degree. I think I did, but the more I'm thinking about it, the more I lean towards. I've always been not guilty. I've always been not guilty all the way through, based on I want to hear everything first. But then I was like, well, maybe if you're second degree or manslaughter, I'll lead into it. But now I'm a bit like, was it self-defense? The question is it self-defense? I believe it was. And because of that, I cannot vote for those charges. However, if I'm persuaded to go guilty, I would vote on one of the reckless ones. Also, for men, if a woman is attacking them, I think they have the right to get the woman off and away from them any way possible. That's fair. Go through the altar corner. FMM is a wrench or potentially criminal channel. Future Mrs. Martin, would you consider giving FMM a red monitor? I'll have the mods. I don't make mods decisions without the mods. You can be
Two
surprised. I
angle
don't.
at
toward the well.
Make no decision. She's awesome though. There you go. So anyway, those are my thoughts. Please have your own thoughts though. I don't like to put my thoughts out there too much. I want you all to come to your own conclusions of what you all think. Here we go. Defense.
All
Erin's
right, we are back in the presence of the jury with the attorneys and Mr. Miu. Mr. Truffison.
May it please the court, counsel. So, ladies and gentlemen, in his opening statement, Attorney Nelson said to you, one of the things you're going to have to determine is what happened on July 30th, 2022. Well, what happened on July 30th, 2022 is a group of drunk teenagers led by the ringleader, Juan Cockfield, saw an opportunity to torment a man who was by himself. They taunted him. They called him names like raper and pedophile and predator. They did this for no legitimate purpose. When they did this, they're yelling and carrying on. It attracted the attention of another group, right? Led by Madison Cohen and Dante Carlson. 6 drunk teenagers quickly turned into 13. 13 against 1. They got in his face. They screamed at him. They called him names. They swore at him. They put their hands on him. And the group of 6, they became brave. The group of 6 became brave to the point that they circle him and start taunting him. They do this to a man who has done nothing, absolutely nothing to them. Then, when that man, Mr. Miu, tries to create some space between him and Madison Cohen, they pounce. They punch him. They push him. They slap him. They hit him again. They choke him from all directions. And Nick Miu acts in self-defense. That's what happened on July 30th, 2022. I just want to give you guys a little bit of an indication as to kind of where I'm going to go, and more importantly, what I think you need to think about when you are back there thinking about the evidence, okay? First is the law. 1, there is no duty to retreat, period. That is the only requirement. In this state, bullies like Madison Cohen don't get to tell us where to go. Bullies like Madison Cohen don't get to get in our face and require that we leave. That's not a requirement here. Keep that in mind. 2, subjective beliefs, okay? When you're listening to or contemplating the evidence and replaying it in your mind, you are to do that and consider the beliefs, not the actions, but the beliefs of Mr. Miu. And when you do that, you are to do that from his perspective at the time that the events were occurring. So while we have a video, that video is from the perspective of Juan Cockfield. The video perspective that the jury is required to consider it is as Nick Miu is holding the camera. I'm going to address this a little bit later, but the idea of provocation. Whether or not Nick intentionally caused harm to Madison Cohen, that is something that you should consider when you're considering provocation. And the other main one I want to talk about is what it means, because it's different here, beyond a reasonable doubt. So normally, beyond a reasonable doubt is this hurdle, and the state has to jump that hurdle in order to prove a case. It's a little bit different here, okay? Because in this case, self-defense has been alleged. Remember when you're back there, Nick Miu doesn't have to prove he acted in self-defense. They have to prove beyond a reasonable doubt that he didn't act in self-defense. They have to prove that his beliefs were unreasonable. Okay? So the way that I look at this video, the main video of Juwan Cockfield, we've all seen the 9-second video where he's screaming at Mr. Miu, calling him a raper. I'm not talking about that. I'm talking about the video that you've seen probably more than you want to. But I'm breaking that up into really 3 parts, okay? 0 to 149 is the first part, all right? Before anything actually happens in terms of the attack. And what is in dispute in that first minute and 49 seconds? I think 2 things were raised in the case that were in dispute. And that is, first, whether or not these drunk teens were actually afraid of Mr. Miu, right? I think to a person, they testified, yeah, we were really concerned about Mr. Miu. And you get to use your everyday experiences in life when you decide what to believe. Does that look to you like teenagers who are afraid of that person? Is that what that looks like to you? Does this photo of drunk teenagers taunting him, does that make you believe in your experiences in life that they're afraid of him? Or is this what drunk teenagers who are terrified, is that what they look like? Does that make sense to you? Because you heard this. As the numbers rose, as the number of people grew, their fear, it decreased. And you've heard Mr. Anderson say over and over again, all Nick Miu had to do was walk away. Well, you heard from each one of those tubers, those drunk teenagers, we could have passed. When he walked over by Madison Cohen, we could have passed. And you heard Owen Pelican. I didn't want to pass. I wanted to see how this was going to play out. Why? Because Juwan Cockfield was recording this entire incident. They wanted to see what was going to happen. They're not afraid. They want to see how this is going to play out. And Juwan Cockfield said it best of all. It's for the culture. He wanted to put it on the internet so other people could see it. And when you're using your everyday experiences in life, ask yourself this. Do people who are afraid of other people, do they walk up on them? Is that what people do when you're afraid of someone? Or do you try to Get away from them. If you're afraid of someone, do you taunt them? Do you call them names? Do you circle around them? Those are questions that you all can answer. Or an alternative hypothesis to them being terrified is, do they do those things because they're drunk teenagers and what they want to do is make a video and put it on the air? Which one of those two things, based on the evidence that you've seen, which one of those things makes more sense to you? The second thing that I think is in dispute, or was at least raised in the first minute and 49 seconds of that video, is whether or not Nick Miu's looking for little girls. Now, Mr. Anderson gets up here and says, no, he wasn't looking for little girls. But he also says, the boys didn't invent that. No, they pretty much invented that. And why do we, or how do we know that? So that's not on video anywhere, right? They don't mention it. They don't say anything about Nick Miu telling them that, right? Every one of them who speaks to the police provides a statement about what happened. Zero mention to the police that he said he was looking for little girls. This gentleman over here, Investigator Schultz, I think he said that he was a sensitive crimes investigator. He saw some of this stuff come across his desk, and that would have interested him. Investigator didn't testify. Said he would have mentioned, if any of these kids would have mentioned little girls, I would have taken note of that. So, what's the alternative? Why did they say that? I would submit to you that what kind of person does what these kids did to him, and what would they look like as people if all they did was pick a guy out and start to torment him? What do we think of people who do that? What do we think of people who call grown men rapers and pedophiles and predators for kicks? What do we think of those people? They had to come in and say that. Because if they don't, we know what we think of them. That's the reason they came in, and they said this to you guys under oath. They got on that witness stand and swore to tell the truth, and they told you that he said he was looking for little girls. Well, the cops got up under oath and told you, no, they never mentioned that to me. What are the odds? What are the odds that that actually happened and nobody mentions it to the police? What are the odds? Two other little points on that. In your everyday experiences in life, would you expect a man that you never met to walk up to you and say, if you ask him, how's your day? What are you doing? Oh, I'm looking for little girls. Would you expect someone to actually do that? Does that make any sense to you? He's with his wife. He has lunch with his wife and his friends. In order to believe what these drunk teenagers are saying, you have to believe that he has lunch with his wife, he's with his friends, they're having a fine time. Ariel loses his phone, and Nick goes, this is my chance. My wife's right over there, but this is my chance to go look for little girls. And I'm going to tell a bunch of drunk teenagers I've never met before, that's what I'm doing. Tell me that makes sense to you. Because you get to judge the credibility of what people have said to you. Okay? But I want to talk about what we know in that first minute and 49 seconds of the video. What do we know? We know, based on the evidence, that Nick's looking for a phone. We know that. Ariel said that, Nick said that. They find Ariel's phone in the river, so we know that. We know that Nick comes up to the teenager's tubes, and we know that Cockfield is looking for a phone, and Cockfield's holding a phone. Joanne Cockfield's holding a phone. We know that Nick Miu walks away from them as he passes them. We know that. We know, right, that the drunk teenagers move toward him and start confronting him. We know that. We also know that Nick sees what he believes to be a reasonable, rational adult. So he heads over there to talk. And what we know is you can see his thumb, he's motioning back, trying to explain what happened. And we know that Madison Cohen, who knows nothing about what happened, zero, starts screaming at him to leave. We know that Madison Cohen feels comfortable enough to put her hands on him for the first time and move him because, well, she's queen of the river and she decides where people go. So she's moving him. We know that. We know that Nick is uncomfortable. So he waits for his group to come over because the state can say whatever they want. He's by himself. So we know Nick does that. We know that when Nick waves to his group, so does Madison Cohen. But there's one big difference here. Her group shows up. And they show up in numbers. We know that the group of teens are brave. And as this is going on, they start taunting this man who's done nothing to them. We know that. We know that Riley Madison comes over and now she thinks it's necessary because she's been anointed something in the river and she gets to tell him where to go. So we know that she puts her hands on him. We know that Nick's uncomfortable enough that he waves the group over a second time, trying to get someone to come to his aid. We know that. We know that Madison Cohen pushes him, puts her hands on him. Again, he tells her not to touch him, but she does it anyway. We know at that point it's 13 against 1. The other thing that we know, because we heard it, was someone in the group, the brave group of 6, tells Nick Miu, you got 10 seconds. In your everyday experiences in life, when someone tells you that you have 10 seconds, what normally comes after that? If we have children, I'm going to count to 3. You got 10 seconds to do this. Nothing's good is coming after that. It's reasonable in our experiences as adults to take that as a threat, right? And if you think about it, they all blamed. They didn't know it. But the guy holding the bag is Isaac. We know it's not Joanne Cockfield, and everybody else denied it. So who's left? Their buddy Isaac. They all blame, without saying his name. It's like, wasn't me, wasn't me, wasn't me. Well, you're saying it's the one person who isn't here. Right? That's what we know. We know everything here I just told you is what we know in the first minute and 49 seconds. And why does that matter? What does,
I can't see the exhibits that I'm delivering files.
And step up and move over to the side.
what does that matter? Why does this matter? Because one of the things you have to consider when you consider self-defense is Nick Miu's reasonable belief that there is going to be an imminent interference with his person. And when you add all of these things together, he has to subjectively believe that. As a jury, as you sit here today, we don't get to look at it and say, what would an objective, reasonable person do? Does Nick feel that way? Does Nick feel, with all of these things listed here, that there is an imminent unlawful interference with his person? And I would submit to you, he does. He told you he did. Right? We're going to see the video one time, promise, broken up into those parts.
What is he on? Whoa! 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 Hey, whoa! What's the way? Oh, God! Yeah! Yeah! What are you talking about? What the hell are you talking about? What? Get away from us! What? What's going on with y'all homie? He's on camera. Scripted. He's on scripted. Yo, the new iPhone got that good quality. What do you say? Yeah, what the hell? Who is this? Yeah. Yes. Further culture! Further culture! Who is that? Further culture! Who is that? Who the hell is this? Doesn't matter. He said he was looking for a little girl. Yeah. That's exactly what he said. We're not out. I didn't have that part on camera. Did I? Some young ass kid. What the hell is this guy's problem, bro? We trying to have fun. He's gonna claim you. He's gonna claim you. We don't want this one.
The second part of the video that I think is important, and Attorney Anderson's talked a little bit about it, is really the 1 second that we don't get to see, right? The 1 second where the state is insinuating and is claiming that Madison Cohen was punched, and where Nick Miu has testified that he raises his arm to get her out of his space. So those are the two possibilities as to what happened in the video that you don't see. And I am, once again, asking that you use your everyday experiences in life when you make this determination, okay? And I understand that people in stressful situations don't get everything perfect. I get that. I'm not holding anybody to this exact standard, but what have we heard in order to prove beyond a reasonable doubt that this happened? Well, You heard AJ Martin say that he grabbed her by the back of the hair and was slugging her from behind. Okay, no one else says that. You hear Alex Vang say he slapped her with a right hand in the face. Then I say, Mr. Vang, how can that happen? He's got a knife in his hand. And he says, you're right, that can't happen. He punched her. You hear Joanne Cockfield, who's not looking at it, he's holding his camera in another direction, says he threw a hook at her. I saw that. Right? Madison Cohen says, she said on direct examination, he hit me with a left hand to the left side of my face. And it said that. Then when I asked her questions and I said, can you explain how that's humanly possible? And her response was, you're right. I get lefts and rights wrong. He hit me on the other side. Okay. But the state says she had a heartbeat in her cheek. She should remember what side of her cheek the heartbeat was in. She doesn't get that right. But how about the things when you use your everyday experiences in life that the state, they didn't talk about when he was up here talking about her issues. He talks about her falling back and people seeing things. Okay, people can be wrong. How about things that make sense, though? We know that she's wearing sunglasses, right? We know that. Her sunglasses are not broken. She doesn't have a mark on her face from being cut by sunglasses. None of that. Is that what would happen if a 250-pound man squared up on a woman and threw a hook to her face? She doesn't have redness on her face. She doesn't have swelling on her face. She doesn't have puffiness, a bruise, or a mark. How do we know that? Investigator Schultz told us, I saw her shortly thereafter, and she didn't have a mark on her. He says, if I would have seen a mark, I would have taken a photograph of that mark. Makes sense, right? She doesn't drop her drink. She doesn't drop her vape. Her cell phone doesn't leave her bathing suit. Is that what happens when a 250-pound man squares up on a woman? She doesn't drop a thing, and she doesn't have a mark. Does that make sense to you all? Or does it make more sense that Nick Miu pushes her out of his space? Attorney Anderson said she's not in his face. Well, most of her friends said, no, she was. She was in his face. She was in his face. She was in his space. Right? If he makes this motion, she's not going to have broken sunglasses. She's not going to have a mark on her face. She's not going to have redness, puffiness, swelling, a bruise. She's not going to drop her drink because he doesn't hit her. Which one of those two things in your everyday experiences in life makes more sense? You get to decide that. And I want you to think about this. She knows the seriousness of the case. She tells the police she takes a photograph or photographs. Then she claims to have deleted them in a homicide case. Then the police say, that's okay. That happens. You give us your phone, we can get the pictures. Right? Wrong. They do a Cellbrite downloaded extraction of her phone. Investigator Schultz doesn't do it, but he reviews it and says, there's no deleted photos that I saw. He even goes so far as to reach out to Madison Cohen's mother, because maybe she either took the photos or were sent the photos. No, not there either. You get to judge the credibility of people on whether or not that makes any sense. That is not provocation. And just briefly on retreat and provocation. I told you when I started, there is no duty to retreat. And that is true. That's the first sentence in the retreat instruction. If you want to, it says you may consider whether or not when he was retreating, or if he had to retreat, whether the defendant reasonably believed the amount of force used was necessary to terminate the interference. You may consider whether he had the opportunity to retreat. Okay? Now you don't have to, but when it starts, when it matters, is when he's using the force. And when he's doing that, he's surrounded. He told you he was surrounded. I asked Lieutenant Hart, do you have any information that would be contrary to Nick Miu's belief or statement that he was surrounded? She said, no, I don't. Where's he gonna go? So he doesn't have to go anywhere. We don't let people dictate what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The drug teenagers don't have to leave either. They told you they could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation. Okay? You have to find that Nick Miu committed an unlawful conduct against Madison Cohen to provoke this attack. He wanted her to get out of his personal space. The bully in the room doesn't get to yell at you and tell you to leave. And then when you don't leave, doesn't get to get in your personal space because you are not leaving. That's not how this works. The last part of the video is the 150 to 205 mark. Okay? Now, you heard yesterday, the state wants to break this video, this last 15 seconds or so, down into stills. 1/24th of a second. No one lives their life in 1/24th of a second. And you're not supposed to in this case, because you're supposed to look at this case through the eyes of Nick Miu. And if you've watched that video, the first time I saw it, I didn't see what happened. I didn't see him pull a knife. I didn't see some of these people get injured because it's moving like this. When you break it down to 1/24th of a second, it's just not how we live our lives. You have to look at those 14 seconds through Nick Miu's eyes as he was standing there in the river. And remember, he told you yesterday that he believed that he was going to die, but he doesn't have to believe that. He just has to believe that he's going to suffer serious bodily injury. That's what he has to believe, okay? And before I start this video, I'm going to ask you this again. What do we know in those last 15 seconds. We know that Anthony and Dante Carlson were asked by their dad to go over there. Why? To help him. Quentin Carlson testified that he was concerned that Nick Miu was going to get the brakes beat off of him. So Quentin Carlson wanted his boys to go assist. I would submit to you that Quentin Carlson was concerned that Nick Miu was going to suffer serious bodily injury if someone didn't help. Alex Vang told you Miu's getting his butt kicked when this is going on. And Owen Peliquin said those guys got on his ass. Right? Anthony Carlson is yelling, stop, stop, stop. He's not yelling it to Nick Miu. Nick Miu's tail down in the water. Presumably, he's telling it to the people who are beating him. Right? That's what we know. Now, Juwan Cockfield found that to be funny for quite some time. You can hear him cackling on how he thinks it's funny that Miu's getting punched in the face and knocked in the face, slapped, okay? But what we know from that video is a 250-pound man, 250-pound man, has been knocked clean off his feet backwards into the water by getting punched in the jaw. That's what we know. We know that in 1 second, Dante Carlson, who throws that punch, runs around to the other side of Nick Miu while he's still on his back, kind of on his lower, on his butt, kind of on his lower back, and he cracks him across the face. We know that. That's not in dispute. We know that AJ Martin, who says he's the peacekeeper, that's what he said. He runs up from behind and shoves Nick Miu while Dante Carlson comes in for thirds and smacks Nick Miu in the face again. I would submit to you at this point, it's coming from all sides and from multiple people. And this man who had heart surgery is terrified as to what's going on. We know, well, let me just remind you of this. At this point, after he's been punched, slapped, pushed, slapped, he hasn't stabbed anyone. Right? And if you listened closely to what AJ Martin said in his testimony, when he was shown the picture of him making contact with Mr. Miu before Mr. Miu stabbed him, he said, he got me before I got him, I guess. What does that tell you about what AJ Martin's intention is? He's back in the water now for a third time after getting pushed down by AJ Martin. And what do we see next? That's Anthony Carlson. He walks right by Miu. Miu doesn't do a thing to him. Mr. Miu doesn't do a thing to Anthony Carlson as he walks by. You will then see, and what we know is Anthony Carlson comes up from behind him, appears to be yelling at him and putting his hands on him. So now Miu has been touched at that point, punched, pushed from behind and slapped. And now Anthony Carlson comes up to him We know that. And then we know 1 second later that Isaac Schuman comes up to him. You guys get to make the decision on whether or not he's choking him around the neck. You get to make that decision. I'm not telling you what that is. You get to decide if that looks like a choke to you or not. So at that point, 4 people have attacked Nick Miu. And why does it matter? Why does any of that matter? Because if you find the following, Nick Miu is not guilty of all the charges, okay? If you find that Nick Miu believed that there was an imminent unlawful interference with his person, if you believe that he believed that was coming, the 19 or 18 reasons that I put up there supports that, and he told you that, and that's his subjective beliefs, okay? If he believed the amount of force that he used was necessary to terminate that interference, okay? So if he believed that he did what he had to do, right? I would submit to you there's only 2 answers to that. Only 2 possible answers. He either did what he had to do to survive, or this man who you watch the video, who's never got a speeding ticket, who decides to go out with his wife that day, who's floating down the river and having lunch, decides, you know what, today's the day I'm going to start stabbing people. I'm going to leave my group, I'm going to go over and I'm going to start stabbing people. Mr. Anderson says he snapped. If he was in fear, he would have left. I think anybody would dispute that he was in fear. So when you're determining whether or not what he did, if he believed that he had to do that to terminate that interference, I would submit to you, why else would he do it? He either believed that or he just lost his mind. Right? This 52-year-old engineer who's married just lost his mind that day. Those are the 2 options I think that you have on that. And the final thing that you need to decide is whether or not his beliefs were reasonable. And the standard is when a person of ordinary intelligence and prudence would have believed standing in his shoes at that moment. Okay? Quentin Carlson is about his age. And Quentin Carlson is concerned enough for his safety that he sends his boys over. Quentin Carlson tells the police that after his boys have been injured. He tells the police, I get it, they're injured. I sent them over there because I was concerned for the old guy. Brandy Hart. Did you watch that video yesterday? There's a point in that video where Nick Miu puts his hand in his head and says something like, my life is over. And Brandy Hart says, I don't know about that. They're self-defense. She says, I don't know what I would have done. But I can tell you, I would have been scared shitless. She's been a police officer for 25 years. And that is her response. State never followed up with her on anything after that. That was her statement to the police. Or that was her statement on the tape. And as I mentioned, Alex Vang and Owen Peliquin say he's getting his butt kicked. They're all over him. Are those reasonable people? You get to decide what a reasonable person would do in that situation. But I would submit to you, you've got something to work with. You've got something to work with. briefly on the charges, okay? Before you even get to self-defense, you get to intent. You have to find intent on the homicide charges initially for Isaac Schuman, and you have to find them for the others involved, okay? And the question on intent is mental purpose. Can you watch that video and say that Nick Miu's mental purpose is to kill Isaac Schuman? Or is his mental purpose to get another person off of him? You get to decide that. Okay. Under those circumstances, you heard everybody say, anybody who never touched him, he never touched. Right? People were like, I didn't want to get near him. They didn't touch him. He didn't touch them. He didn't say anything. You get to consider all the facts and circumstances. He didn't say anything to Isaac. Right? Isaac grabs him by the throat and he stabs him one time. Is that an intent? Is that his intention to kill Isaac Schuman? And when you started this case, you heard that was the charge. Well, those charges have changed. Now you get to consider all other kinds of charges with all other kinds of mental states too, right? Maybe it was intentional. Well, maybe not. Maybe it was reckless. Pick a theory. Don't let them just throw things against the wall and hope that you guys let something stick. They're telling you they thought it was intentional. Now it might not be. Now it might be reckless. They don't have it. Nick Miu wanted to get Isaac Schuman away from him. He didn't chase Isaac Schuman down. He didn't move toward Isaac Schuman. Isaac Schuman moved toward him. And on the attempted homicides, read the instruction on attempt, you guys. In order to convict someone of an attempted homicide, the state must prove to you beyond a reasonable doubt that demonstrates unequivocally that Nick wanted to kill these people and would have, except for the intervention of another person or some other extraneous factor, okay? And unequivocally means there can be no other inference which can reasonably be drawn. No other inference. And an extraneous factor is something outside the control of Nick. You heard DA Anderson say, but for medical intervention, some of these people would have died. Well, AJ Martin would have. Dante Carlson had a hernia. He repaired a hernia. Sorry, medical intervention doesn't prevent him. He's not going to die from that. Anthony Carlson gets 2 stitches. He's certainly not going to die from it. And Riley Madison could have got an infection, they said. I understand that. But if he wanted to kill them, why didn't he? If you believe Attorney Anderson, he's alone with Dante Carlson. Why does he stab him one time? He wants to kill him. Why doesn't he smash him up? He wants what he wanted all along, to get away from these people. He's leaving, and Dante Carlson, who has beaten him up, has hit him in the face repeatedly, confronts him again. What does he think? What does Nick Miu believe is about to happen? You don't have to let somebody beat you before you respond. Doesn't that make sense? And because they don't have the attempts here, because there was no outside extraneous factor, they also say might not be attempts, take a chance on reckless. How about that? Again, not really a theory, but you get to make that decision. I'm going to comment on the video because I think it's appropriate that was played, the interview with Nick and Brandy Hart. He lies about the knife. He lies about the knife. What he and what Lieutenant Hart said is he's never wavered on is that this was self-defense, that he was fearful and that he was being attacked. Okay, that he's never wavered on it. He said it over 20 times in the interview, and it's the first words out of his mouth when he's interviewed by Lieutenant Hart. Some people get some facts wrong. Some people lie about stuff. He's not telling you the truth about the knife. But does it change one thing that you saw on that video? That's the reason we want there to be a video. Is so you're not taking the word of 13 people who don't get it right. That video is not subject to change. Attorney Anderson's right. It is what it is, right? What has persevered through this case is Nick Miu's fear, how he felt, the shock. You heard people testify about that. The whiteness, the wide eyes, the ghost-looking color of his skin, that has persevered through this case. He lied about the knife. Doesn't change one thing that's on that video. You should feel sympathy for Isaac Schuman's family. I have a 19-year-old son. He would be in Isaac Schuman's grave right now. Everyone feels sympathy for Isaac Schuman's family. I'm sure he was a wonderful kid. And I know that his parents love him. But you don't get to decide this case based on sympathy. The judge tells you that. You decide this case based on facts and evidence. That's what you are required to do. And put most succinctly in terms of the burden of proof and what the state has to do is they have to prove to you beyond a reasonable doubt it's not self-defense. And what does reasonable doubt mean? Well, the judge read it to you. You'll get to hear about it again. But it's a doubt that would cause a person of ordinary prudence to pause or hesitate when deciding the most important affairs of life. And I would submit to you the most important affairs of your collective lives are your health, your family's health, loved one's health. When you're thinking about that and you have to make hard decisions on those things, if there is a pause or hesitation about what you need to do because you're getting information from various places, you say, I need a break. I need to figure this out. That's reasonable. Okay. It is a doubt for which a reason can be given. That reason is self-defense. And I just want you guys to know this. When you go back there and you have those verdict forms, if you believe it's self-defense, he's not guilty. If you believe it's probably self-defense, he's not guilty. If you believe it's possibly self-defense, he's not guilty. If you're like, it likely is, I don't know, not guilty. If you believe it might not be, not guilty. If you believe it's probably not self-defense, not guilty. All of those considerations that you would have require a verdict of not guilty. because the state has to prove to you beyond a reasonable doubt that it wasn't self-defense. So as I go to sit down, we, Attorney Nelson, Nick, you and I appreciate all of your time. The time that you've taken away from your families and friends to do this. The attentiveness that you've given us. And I think it's time for people to go home when you're done. And what we're asking that you do is that you send Nick Miu home. That you find him not guilty on all of the charges. Thank you.
While we swap people out, if you'd like to stand and stretch for a moment, you may do so. And then we'll hear a brief rebuttal from Mr. Smithstone.
That was 54 minutes. So the state was 56, defense was 54. That was a very crucial ending in the sense of, because I forgot, you sometimes forget if you believe it's probable, possible, or definitely, then it's not guilty. Even if you've got a slight question in your mind, it's probable cause. So that might stick with some jurors.
You just heard Mr. Dropsy say his entire defense is based on what Nick Miu told you during his testimony was thoughts in his head, the beliefs in his head. What do we know about Nick Miu? We know he's smart, speaks multiple languages, has a couple of degrees, one's in math. He's a calculating person. He's a cunning person. He's a skilled and prolific liar. We know that because every word that came out of his mouth, practically since he started walking away from this group, was a lie, including to his best friend, who he said they took my knife while the knife is still on him. The things he said to Sheriff Knudsen, where he pretended to not know what was going on. And then everything he said to Investigator Hart, Lieutenant Hart. He is skillful at crafting a story that matches what he needs to say to avoid the consequences for his actions. We all know that. It's undisputed. He told you himself he's a liar. All right? He did not just not lie about the knife. He lied about all kinds of crazy things, bizarre things. Why would he say that these boys pulled his pants down? What a bizarre lie to make up. Right? Why would he say that two boys pulled knives on him? He's got to say that because he knows what he did wasn't justified. He thinks to himself, if I say one boy pulled a knife, that would be good. But if it's two, that would be better. So he crafts this elaborate story. His entire defense rests on you believing what he said on the stand yesterday. His testimony was a disaster. He got caught in several lies on the stand. He changed his answers a couple of times when he realized that what he said wasn't helpful to his defense, right? He consistently remembered details from July 30th, 2022 that benefits his defense, but doesn't remember anything about what he did, any of the facts, any of the stories that he told Lieutenant Hart. How is that possible that he can only remember the facts, the beliefs he had that assist his defense, and nothing else? How many times did he say on the stand, I don't remember, I don't remember, I don't remember? He repeated it over and over and over again because he doesn't want to answer questions about what he did because he knows dang well it wasn't justified. He's lying. He's lying. One of the many things I'm going to be grateful about when this is done is that I never have to hear again that the actions he took that day was the fault of these boys. That's ridiculous. It's despicable. There's never been any explanation from the defense as to why Nick Miu ran up on these boys, why he grabbed their tubes, why he was groping around for their legs were. They don't even respond to it. They didn't bring it up. There is no explanation. That behavior is inexplicable. He's a bizarre person. He made bizarre choices that day. It is not their fault. It is not their fault. I'll say it 100 times. It's not their fault. These boys have beat themselves up every day since this happened. You saw the raw emotion on the stand. Their best friend was murdered by this guy. And to say that it's their fault is despicable. Nobody's responsible for Nick Miu's choices but himself. He chose violence at every turn. There's been some question about whether he's fragile. Part of him is fragile. His ego is fragile. As his attorney had said early last week, when he's questioning these boys, you were trying to humiliate him. You were trying to insult him. You were taunting him. He was humiliated. He was insulted. He didn't like these boys treating him like that. He certainly didn't like Madison Cohen getting in his face, so to speak. And eventually, he did just snap. He pulled his knife out, getting ready for violence, pulls it out, holds it down where nobody can see it, holds it at his side, and then hits her. That started the violence. He prepared for the violence before he started it. He felt humiliated, and he wasn't going to let it go. I asked him, did you ever take a step back at any time when she was yelling at you? No. With no explanation. We're dealing with what we call false narratives in this case. Things that the defense repeats over and over and over again, hoping that you think it's fact, okay? One of these is this 13-to-1 narrative, okay? We've heard it 100 times in this trial. This is not a 13-to-1 situation. We've got the 6 teenage boys standing on the side by their tubes. He's confronted by the 2 girls. Everybody else is in the background. He hits Madison Cohen when he's only got 2 girls standing in front of him. After the fight, it's one-on-one to start. It's Dante hitting him, and then arguably 2-on-1 when AJ comes up and pushes him in the back. Tony breaks it up. The fight's done. He gets off. And AJ, of course, is already tore open, so he's laying in the river. But that's the end of the fight. Mr. Miu continued violence. He chose more violence after that part of the fight was done. Tony, who did exactly what his dad told him to do, came up to try to break it up. You can hear him telling Dante, his brother, get away, get back. Mr. Miu turns around and stabs him, and Tony blocks it and stabs him again. He chose violence at every turn. There's another false narrative. They circled him. They surrounded him. Baloney. You've seen the video how many times there's open water everywhere. That he was attacked from all directions. False narrative. He said that Owen Peliquin testified that they stuck around because they wanted to see how it played out. That's true, but what he didn't mention is that Owen also said he wanted to make sure he didn't do anything to this woman. And you know what? Those instincts were exactly right. Those instincts were right. He keeps talking about how these boys wanted to make a video. Well, they were making a video. But what does that matter? They didn't start the violence. None of those boys laid a hand on him, despite the fact that he touched both Joanne Cockfield and Landon Wire when he ran up on them in their tubes. Nobody laid a hand on him until after he had already stabbed a number of people. Isaac Schuman tried to stop him. He got killed for his efforts. He seems to be arguing, the defense seems to be arguing that Isaac somehow deserved it. I don't understand that argument. He's trying to protect people. He calls Maddie Cohen the queen of the river, and he calls her a bully, calls her a number of other unkind things. Her testimony was, and it's clear from the video, she was trying to protect these boys. She saw that he was over there doing something, that it was freaking them out. She tried to protect them. You know, maybe if we had more people on the river trying to protect people, the world would be a better place. They've made over and over, they've argued that Maddie was never punched because she has no marks on her face. Nick Miu, who, as Mr. Trosty said, was lifted off of his feet by the punch from Dante and punched in the jaw and fell in the river, gets up and there's no marks on his face. We have pictures from him. We have the video. We have his interview with Lieutenant Hart later. We have the pictures that the jail nurse took 5 hours after. There's no bruising. There's no puffiness. There's no swelling. The fact that they're arguing that Maddie had no mark doesn't matter because he didn't either. It happens. They're trying to say that he was terrified. His face tells a different story. He has expressions of anger. He has expressions of, I guess, humor. He's smiling. He's smirking. Well, after he has his knife out, he clearly feels comfortable. There's no look of terror in his face at any time. KJ Martin was not armed. He pushed Mr. Miu in the back. We know that. He didn't kick him. He didn't punch him. He didn't hold his head underwater. He pushed him in the back. And for that, he got a incision on his body from his belt line all the way up. You saw the pictures. It's horrible. He used no weapon against Mr. Miu. They made a big deal about Lieutenant Hart telling Mr. Miu in the interview that she would have been scared too. Well, she made that response after he'd been feeding her a load of BS about all this stuff that supposedly happened. About having 2 kids pulling knives on him and pulling his pants down and all the baloney that he fed her. Based on that, she said, yeah, I would have been scared too. They're arguing that he had no intent to kill Isaac. Isaac weighed 134 pounds at the time. He's 250. He rams his knife up, not down, up, severing 2 of Isaac's ribs right into his heart. All right. If he didn't intend to kill him, why not stab him in the belly? Right into his heart. We've heard no explanation whatsoever as to why he stabbed Riley Madison. We know from the video she's standing off in the background after Tony's trying to break it up. He just walked over and stabbed her. She wasn't attacking him. They don't explain that because there is no explanation. None. He wasn't in fear for his life from Riley Madison. She said she was 110 pounds now, might have been 115 back then. There's no fear for his life. He just was mad because she touched him. They've talked a little bit about the extraneous factors. It's not just medical attention that can be an extraneous factor. As we know, multiple people on the river stopped to help these folks. Putting compressions on. One witness said they used a sandwich bag to try to make a chest compression. There was a lot of interventions for these folks. We know with Riley Madison specifically, that Larry and Davis and his brother, we saw it on the video, got her to shore on a tube. People went out of their way to help these folks. These are extraneous factors. But another extraneous factor is he just got unlucky. You know, if he, as Mr. Anderson had said, we've got arteries, we've got organs. Dr. Meyer said, you know, whenever you have an abdomen wound, you have to check all those things. It's kind of a miracle that more people didn't get killed. It's not by anything he did. He just got lucky. Missed major organs and arteries. The bottom line is he had 4 hours from the time that he was arrested to the time that he concocted this ridiculous story about the boys pulling knives on him and pulling his pants down and all this other bizarre baloney. He used his intellect, because we know he's smart, to craft this story. And he was very deliberate and detailed because he wanted to come up with a story that he thought would be sufficient to convince people that he acted in self-defense. We know he lied about all of it. So now today, he's saying, well, sure, I lied about everything I said when I talked to Lieutenant Hart about what happened, but now I'm telling the truth. So now believe me. No, no, no. You have my full confidence. I know you're going to return just verdict of guilty and deliver justice to Isaac Schuman and everybody else who got hurt by this man. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law that should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether Mr. Miu is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide, and they must not affect your deliberations. Multiple forms of verdict will be submitted to you concerning the charges against the defendant, Nicolae Miu. For count 1, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of first-degree intentional homicide as charged. Another form, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of second-degree intentional homicide as submitted. Another form, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of first-degree reckless homicide as submitted. Another form, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of second-degree reckless homicide as submitted. Lastly, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu not guilty. Return only 1 for your verdict. If you return a guilty verdict, you must also answer this question. Did Mr. Miu commit the crime while using a dangerous weapon? As to count 2, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of attempted first-degree intentional homicide as charged. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of attempted second-degree intentional homicide as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of second-degree recklessly endangering safety as submitted. Finally, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu not guilty. Again, return only 1 for your verdict. If you return a guilty verdict, you must also answer the dangerous weapon question. As to counts 3, Dante Carlson, count 4, Anthony Carlson, and count 5, Riley Madison, the court will give you 5 verdict forms for each count that are worded similar to the ones given to you for count 2. As to count 6, Madison Cohen, 2 forms of verdict will be submitted. One reading, as to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu guilty of battery as charged. Next, as to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu not guilty. Again, if you return the guilty verdict, you must answer the dangerous weapon question. It is for you to determine whether Mr. Miu is guilty or not guilty of each of the 6 counts submitted to you. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, please administer the oath to the bailiff.
Do you swear that you will, to your utmost ability, keep all jurors on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed upon your verdict, and if they are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
The bailiff has extra copies of the jury instructions. I imagine you'll probably want to consult with them during the course of your deliberations. I believe he has 4 or 5 sets. If you need more, let him know, and I will print more for you. He also has the verdict forms in each of the manila envelopes, 1 envelope per count. If you reach a verdict, please put that verdict signed by the foreperson back into the envelope. The other forms that you don't use can be discarded, but there only should be 1 verdict form returned back in each envelope. Now, members of the jury, as I mentioned to you at the beginning of the trial, only 12 jurors can deliberate. 2 alternates were seated in the event that we lost jurors due to health, emergency, or some form of misconduct. The alternates have been determined by lot by the clerk of court. The alternate jurors are not released from jury duty. Alternate jurors may be called upon to deliberate if we happen to lose one of the 12 jurors during the course of deliberations. So basically, the alternates are needed to be at the ready and stand by in the event that they are needed. The alternate jurors will be free to leave the building, but you may not talk about this case with anyone. You may not research or investigate the case on your own. You may not read social media posts. You may not read news reports about this case. If we need an alternate juror to participate in deliberations, the clerk of court will contact you. So we'll need a phone number before you leave. You will be expected to return relatively quickly. So please stay close to home or close to your place of work if it's nearby. We will keep your personal notes safe in a secure private location in the event that you're called upon to deliberate. At this time, I'll ask for the envelope. The 2 alternate jurors are Darren You may. If you'd like to have a private place where you can eat it here in the courthouse, we'll provide you with that facility. But the alternate jurors may not eat with the other 12 because the other 12 may begin their deliberations once they are back in the deliberation room. Please take the jury out.
All rise for the jury.
Please be seated. Mr. Anderson, do you have any objection to the manner in which I read the jury instructions?
No.
Mr. Trofasi, do you? All right. The alternate juror forms, or the alternate, I don't know what you call this, the jurors selected for 12 the 12 jurors selected for deliberation are listed on the form if either of you need to see it. The clerk has it and you may look at it. Before we adjourn, attorneys, please stay close by in case there are questions. I do want to compliment both of you, actually all of you, on your conduct and demeanor during the course of this trial. It is difficult subject matter. It is difficult law to get your mind around. These were tragic events, traumatic events, and I thought you carried yourselves with dignity during these proceedings. And I think your clients, the victims, and the community should be proud of the way that you have administered justice today. You both have given this jury a lot to think about. We stand in recess.
Okay, recess. Right. Hold on, before I forget, let me just do one thing. Oh, my darling, I can't believe it. You are me. Thank you to, if we can do this. I didn't have a chance to do this until now, so apologies in advance. Thank you to Wendy H. Thank you for supporting Free MLS, hashtag Free MLS. So if you want to support MLS and get his channel back, or to stick two fingers up at YouTube and the Hales and stuff, hashtag Free MLS. And also FMM 2.0. Thank you for the 4 copies. Glad to have found your channel. You're doing a great job. Look forward to seeing your channel grow. Thank you, Adalian. I really appreciate that. And oops, I need to skip this because I've got anonymous there. Here we go. 2 seconds. Also, Kristen Felton, thank you for 3 coffees. Thank you, Delano. Thank you, Kristen. I'm blessed. Thank you very much. And Chudley Pip, thank you for all you do in bringing these live streams, trials, and chats. You do a fab job. Thank you very much. Chudley Pip, as always, way too generous. But I just want to give you all a shout out. And thank you to the anonymous person who I will not shout out because they asked me not to. Thank you for the 5 coffees as well. So, champion, thank you. I tend to do these every breaks, but this is the first break properly. What's that? Do you know what? I was going to message privately and say, because I wasn't sure who Kristen was. So thank you, Ross's mum. I didn't know. I was going to message you privately. I was going to message Kristen privately, say, hi, what's your username? So thank you. Right. We got. So again, thank you very much. I will explain it now to you, Dirk. Share screen. What I'm going to do now is play you this. We'll play this in a bit. This is the jurors. So I'll play it in a second, right? That's what I'm going to play for the next whatever. So what's the capital? So just to give you a brief, I've been reading through it this morning. You know, I don't want to create too much drama, but essentially, Dirk, he's lost his channel. He's losing his channel in 5 days because Jeremy Hales, that piece of shit, struck him 3 times, which is diabolical. It's diabolical to anyone, like members of the public, but a fellow content creator, if you can believe it, did not like what David was saying, said that it wasn't fair use what he was doing, and struck him 3 times. And because of that, he's now losing his channel. He's created a new channel. Fuck, I don't have a link to it. I did post the link. It's in here somewhere, but I'm sure Josie or Erin or somebody or Murph can grab the link. He's got 2 new channels. We will put his channels in the chat, and you can join them if you haven't done so. If you follow MLS and you're a member of his old channel, or even if you're not an old member of his old channel, go and support him. Stick 2 fingers up to these fuckers that have eaten his channel. There's nothing worse. Sorry, I need a mic. Bloody hell, I'm such a boomer. I'm such a shit host. I always forget about my mic, or I mute myself. Oh, I had to check to see if I muted myself. We will post his links again. So essentially, Jeremy Hales copyrighted him, and he's now lost his channel. That's a content creator's worst nightmare. I couldn't even think what I would do, and I nearly lost my channel once, and I could have cried. So he's starting from scratch, which is not a good. Like, I know he's going to get there quick. Um, but he's currently not monetized or anything. He's he's not making money, which he deserves to make money because he does great content. And yeah, and unfortunately, for whatever reason, Dirk, this is why it's bad, because you don't even know about it, Dirk. You're in everybody chat. Do you know what I mean? Um, it seems like lots of people aren't very supportive of it. So get the messages out there. If you're on Twitter, get messages out, hashtag free MLS. And if you search for free MLS on Twitter, you'll see lots of different people that are tweeting. Tweet at people, put the message out there. Tweet at Team YouTube and at YouTube. Yeah, it's disgusting. And as I say, if it can happen to David, it can happen to any content creator, some of your favorite content creators. And David's not a small channel, but he's not a massive channel. So I say it can happen to anybody. So please go out there, yeah, and tell them to go fuck themselves. Do you know what I mean? As in, to copyright like that, that's not good. And it's disappointing to see there's not many people in the community that are supporting David. I'm actually embarrassed about that. But yeah, so please go out, follow him. If you're not a content creator, go follow him in his new channels, and then obviously put the word out there as well. Um, right. So that's essentially what it is. Right. Attorney Andrew Branca. Right. We'll go through the jury now. No, it's 3 strikes now. He's had 3 strikes, yes. Right, hang on. No, it's hey, there's no such thing as free speech, apparently. People preach it, but they don't actually believe in it, allegedly. Right, let's play this then, what Branca says about the jury. As I say, we'll get the links for MLS up in a little bit. I'll say I'm not going to trust it every time, because I'm not here to create drama on it. Because people will say, "Oh, you're creating drama." No, I'm just trying to get a message out about a fellow content creator that does not deserve this. Right, here we go. Branca for you. Hang on.
The makeup of the jury, according to this graphic, right now we have 14 because there's 2 alternates who will be dismissed. 8 of those are men, 6 of those are women. But look at that age breakdown. 8 of the jurors are 50 years of age, so this defendant's age or older. How many of them do you think would want to be in this circumstance? Facing 13, mostly men, 17-year-old high school football players, and young men, 20 years old, 24 years old, half their age, 13 of them on a river, and fight to defend themselves without resorting to deadly force. So that's those guys are going to see themselves in this defendant. even if 2 of those get dismissed as alternates, that's still half the jury that's 50 or older. One of them at 90. I know, it's quite remarkable. So let me take a quick look at chat. If I can find my chat. Yeah, I was thoroughly unimpressed by that state closing. Sometimes you're blessed and the prosecutors are no good. They don't appear to me to be very strong here. Yeah, Will Parker points out the only purpose for much of the questioning by the state was to frustrate the defendant to get him to lose his composure. And that's true. They're trying to provoke you to some kind of outburst. The state obviously badly mischaracterized the evidence repeatedly. Prosecutors slowing the event down with all their frames like Binger did in the Rittenhouse trial. I pointed that out. We had a low IQ response in the YouTube chat, of course. Yeah, I don't know why the defense didn't play the whole video again. I would have played it with freeze frames. Let me pick the freeze frames. So you hear the noise, hear the shouting, hear the taunting, hear the pedophile, hear all that. Freeze. Every time hands go on. Maybe they'll do that on closing. That'll be nice. This person, hands on, right here. This person, hands on. This person, hands on. Everyone who got stabbed, put hands on this defendant. Let's see. Tony says, I wonder if Mr. Miu ever trained at ShivWorks. ShivWorks is Greg. Oh, good heavens. What's Greg's last name? Greg Douglas. Former cop, does a lot of force-on-force training. I know Greg personally. He does a fantastic job. If you can take any training with Greg Douglas is well worth taking. His force-on-force training is exceptional. A lot of places now do force-on-force. Most of them do it poorly. He's also got a custom brand of knives out, knife training, fixed blade knives. I own a couple of those. Does great work. Highly recommended. I don't know what he thinks of me. I have a mixed reputation in the self-defense community because I'm somewhat disagreeable. But I don't care what other people think of me. I care what I think of them. And I think Greg does great work. Let's see. Yeah, I think, I say there's a risk to putting the defendant on the witness stand, and there is, but there's also a risk to not doing it, right? I mean, look at Zachariah Anderson. That trial, he didn't take the stand, he got convicted. In a pretty sketchy trial, a pretty sketchy prosecution. The prosecutor there was at least as sketchy as these, and in many ways much worse, in my opinion. Would that outcome have been different if Zachariah Anderson had taken the witness stand? I mean, I don't know. But I think often if you've killed someone, and here we have a defendant who's killed one person and stabbed 4 others, some of them pretty bad, and you're claiming, hey, I'm just a normal dude who was defending myself, often the jury wants to hear from you. They want to hear, all right, well, listen, maybe there's a good reason why you killed a 17-year-old, but we need to hear it from you. So he certainly did not just grab his knife and go charging after children, for sure. All right, let me see if there's any super chats that need to be addressed. Super chats need to be $10 or more, folks. I don't know why you would do that. I discourage you from doing that. I would suggest that instead you become a Law Self-Defense member for 99 cents. Get all your questions answered for free. But that's up to you. Looks like there's a couple. Susie, I think this is from earlier today. What's your opinion so far? I just did my analysis breakdown on that. In fact, I should make a timestamp. Yeah, that's okay. I got a timestamp from when they ended. Alex, what's the likelihood of a threat resulting in your end SBH required before you can use deadly force in self-defense? Can you use deadly force to prevent a 10% chance they hurt? Oh, SBH, serious bodily injury. 25%, 50%. you need to be facing an imminent prospect of serious bodily injury. It just can't be completely speculative, right? Some people like to say, well, I've seen videos where a person is punched once and they fall over and hit their head, get knocked unconscious, fall over, hit their head and die. That means punches are deadly force. No, because what the courts look like is what typically happens. And those outcomes are very rare for a single thrown punch. So it doesn't get that complicated. I wouldn't bother breaking it into percentages. Is it reasonably likely to cause you death or serious bodily injury, loss of consciousness, maiming injury, blindness, inability for you to defend yourself, rape? Some states do provide a statutory definition. They'll list a whole bunch of things like that. But then there's always a catch-all as well. And some states don't define it. They just say serious bodily injury, and then they leave it up to the appellate courts in their opinions to define it. But if the risk of serious bodily injury is 1%, it's almost certainly going to be treated as entirely speculative by the courts and not realistic. Swissgar 2322, $20 super chat. Thank you so much. Do you think this would be a good close? This is what the state wants you to see. Show still frames. This is what happened. Play the video start to finish. What part of that do they not want you to see? Yeah, I think phrasing it that way would be fine. Again, what I'd really like to see is the entire video with freeze frames every time someone goes hands-on. I think that would be pretty compelling. All right. Let me see what's going on in court, shall I?
Oh, right. So I didn't even watch it, so I don't know what you said. Hang on then. No, it's a case of what the fuck do we do now? I'm waiting for them. I know what I'm going to do. Stop screen. Get that out. And what we'll do next. So I just wanted to come out and support David. Oh no, we're not saying the text. I'm 100% on board. I know exactly what you mean. Because I shouldn't even have to. I said earlier on, I've not even spoken to him since September, and it's like, why am I have to? I would have come out anyway and said something, but where's everyone else? Do you know what I mean? It's like I've heard some people say, "Oh, yeah, we don't want to cause drama for David." I was like, well, so that's what I mean with David. I'm not going to cause drama for him if he doesn't want it, but I think it's bigger than that. I think this is bigger than just David and Jeremy's. This is content, This could happen to any of us, it's ridiculous. Call up Happy Days FM. Let's go. Oh, and also, I'm not sure if you saw the shout out again. Thank you for the coffee, FM. Really do appreciate you for that. I'm really grateful. Thank you very much. So should I Google a biscuit and gravy? No, don't. Thanks so much, lad. Exactly right. Where's everyone else? All these members are in, but where are the other kind? Yeah. I'm shocked. I'm shocked. But that's what I mean. I'm not calling. I have no idea why they're not. I can only presume, but up to them. But I just met David on Facebook before he started his stupid. Dave, you're old school hamburger. Dave is a hamburger of old school. Make you laugh, winning. Let's go, because you always make you laugh. I love it when people come in and no, you don't have to make me laugh. I love seeing people. People maybe banging their heads in shame about the situation or don't want to say anything to support David and lose all the new subs and super chats they've begun. Yeah. Yeah, I mean, if you're hanging your head in shame, I just think you come out and say, look, I was wrong. Sorry, David, I was wrong, everybody, But I'm afraid I'm afraid it's mostly the second bit, I think. Don't want to lose new subs and super chats. Some things are bigger than bigger than that. My message to everyone is just hope it never happens to you. Hope it never happens to them, because I guarantee you that any of them, who would be the first one there to support them? I'm pretty confident Dave is probably in the top 3 people that would have be helping them. Hamburger, what was that, 10 years ago, Dave? I can imagine you being on Facebook watching streams, watching trials, giving your wife hell, watching Oregon, watching Green Bay, watching trials. Enjoy company, even though I'm doing boring stuff. Well, you guys keep me going, so it's all good. I'm grateful that you guys are here, keeping me company. I just don't know what to do now because I got a few things to play. I'll play a few things, recaps, I think, from the trial because there's not. I don't think. I don't think that they're not going to come back with a verdict today. So, but I don't want to just leave just in case, you know. He's been around for a while. He's had videos out for many years. I wish I'd discovered his channel much earlier than I did. Found him when I was searching for something else. You see, it's random, isn't it? I noticed the first strike, all of a sudden, they didn't want to talk about drama when it affects their money. Oh, yes. The only one I heard about Cover the Hales that has responded. Has he responded now, has he? Well, no, he hadn't responded yesterday. I'm out of touch. I'm not looking at it, but I know he didn't respond as of yesterday. Sorry, something's come up. Yeah, I didn't know he took down all his videos. I knew he took down his videos, yes. Just to shut you up, probably, Dave, so you can ban yourself. Did you see the? Yes, I've not read it, but I've seen it. Yes, got to run, Chappie. Stay English, my man. Stay. See the bit, Erin. I never thought about YouTube until I started watching M&S New. There we are. Let's go, Dave. Sorry, I'm back. So it was, oh no, I'm not interested in drama, making no mention, but still supporting his. I mean, I don't agree with them. Like they're not causing drama. When I say causing drama, them coming out doesn't cause drama whatsoever. They can do that, but at least acknowledge that the strikes were over the top. There's so many ways you could do this. It's not even. Anyway, it's up to. Look, people see who's supporting what I'm just sure. I didn't even know that no one was supporting. Anyway, I'm going to move away from the subject on this video because I don't want it to turn into something else. But I get enough shit. But what I'll do now is I will play a video. Hey, Mighty Meat, Mighty Meat in the house. Hang on. No, you can do it in chat. I don't mind you talking in chat, Chris. It's fine. I want to get back to this trial, but feel free in chat. I don't care what you chat about in chat. So crack on. I'm just trying to find a stream. Nicolae Miu. Where the fuck? Right, I need to find another Nicolae Miu one for you guys once I go and get some lunch. Hello, Maureen. How you doing, darling? You see, you've got to remember as well, I'm a man. I'm a man, not a boy, man, not a boy, man, not a boy. So I can't do two things at once. Nicolae Miu. Oh, do you know what I'm going to do? I know what I'm going to do. I know what I'm going to do. I know what I'm going to do for now. For the next hour or so, I will put this up because hang on, I got you.
Schuman moved toward him. And on the attempted homicide, read the instruction on attempt, you guys. In order to convict.
Right, I'm going to leave this up for you guys. You can watch some stuff if you want to, and I'll be back. Have you watched the George Kelly trial? No, I've not. George Kelly? No, I haven't watched any of it. Don't even know what George Kelly is, to be quite honest with you. George. Oh no, but you know what? Sean's covering it. I believe Sean, potentially criminal, is covering it. Hang on. Oh, fuck, wrong one. I keep doing this. Why do we do this all the time? I have no idea. So, if you want to see some stuff on that, you know, sure, fine, okay. I think the court stop. FM's here, so he might. Maybe she can tell you why. No worries. See the bit, Chrissy. I'll play this now, right, guys? So you can see. I'm gonna go for a little bit of lunch, and then this afternoon we'll come back and we'll do something else, and we'll watch something else. But I'll keep this going so you've got something in the background at all times. If you haven't seen stuff, you can catch up. They'll be giving commentary and stuff like that. But there's a link to Sean if no one's joined this channel before. I'll see you in a bit, Chrissy. I'll see you ever in a bit. I'm just going to grab some lunch and stuff. Dave's going to explain some stuff to you as well. Right, hang on. Yeah, I know nothing about it. That's why I thought you might go to Sean so they can then get his take on it. Right, I'll leave you with this, guys. For a second.
Case, I think he was really arguing that the intent isn't shown by his actions. His actions are showing self-defense. One cut, stop, doesn't then jump on top of someone and continue to stab them repeatedly, punch them, just try to drown them, etc. So I think that it was important for him to touch on that with regard to the fact that these individuals would not have died, and that most importantly here, it was not Nicolae Miu's intent to kill them.
And Debbie, I want to get to one more live poll we've been running this afternoon, getting back to the lesser included, the addition, of course, of like the reckless homicide count and the recklessly endangering public safety, adding to the top counts already charged. And we're asking our YouTube live stream audience if they feel that changes the dynamic of the case. We've got over 7,000 votes, and it's running 75% say, in their opinion, doesn't change the dynamic of the case. 25% say yes. Adding those charges in the end, even though legally allowed, and certainly happens in every case, whether it's on TV or not, or can happen. they're saying yes, 25% say it does change the dynamic. For them, 3/4 say no. Do you have a reaction just to, I know it's not scientific and it's certainly not the 12 jurors in the box.
Right. And as we've been talking about, Paul, self-defense applies to all of these counts. So, I tend to agree with the 75% in that it doesn't change things significantly, because if these jurors believe that Nicolae Miu acted in self-defense in accordance with the law, it would be not guilty verdicts across the board.
And Debbie, I want to give you the last word. We so appreciate you sticking with us throughout this morning and joining us a couple of times during our trial coverage. And who knows, maybe we'll see you on the back end of a verdict. But I'll give you the last word. Any thoughts that you have as this jury begins deliberating Nicolae Miu's fate here after lunch?
I feel for them. This is a very difficult decision. They have extremely complicated law. And, as any attorney, be it a prosecutor or a defense attorney, will tell you, all that we want is for a jury to be fair, objective, and apply the law to the facts as they've seen them, and set emotion aside. So that's what the defense and the state is hoping for here. And this jury does not have an easy task in front of them.
Debbie Lang with the final word. Debbie Lang is a well-respected local criminal defense attorney for Hallberg Criminal Defense here in the Twin Cities. We so appreciate your insights throughout today and last week when you joined us. We'll stay in touch, and if there's news, perhaps we'll get you back on. Thank you so much. And with that, let's take one last look, Ryan, at the state seal in the court room, just to show you we do have our camera that will remain up during jury deliberations. As we know, the jury has gone back to begin lunch. There it is. We will have that seal. All eyes on that. We have a crew at the courthouse. I'm obviously back in our Fox 9 television studios in the Minneapolis area, monitoring everything. But as soon as we see any activity inside that courtroom, if it's a jury question, if for some reason this jury shocks the world and comes back with a quick verdict, we will be here and bring you live coverage immediately. We have promised you gavel-to-gavel coverage, and we will do that if there are any public proceedings whatsoever in this case. At this point, we will come back. As we approach 1 o'clock, the top of the hour, Central Time Zone, 1 o'clock, I want to take you back. Nicolae Miu on the witness stand yesterday. It's several hours long. It's 3 hours. Again, knowing our viewers, especially our live streaming audience, doesn't watch every single second of our coverage, but we want to take you back to Nicolae Miu's testimony yesterday, a withering cross-examination. He's on the stand for some 3 hours. Of course, now his fate in the hands of this jury, 12 residents of St. Croix County, Wisconsin, deliberating on his fate. But for now, we'll go back, watch his testimony from yesterday. And again, as soon as anything happens inside that courtroom, I promise you, we will take you there live as it happens. For now, Nicolae Miu, courtroom testimony from Tuesday.
Mr. Nelson.
Judge, the defense calls Nick Miu.
Mr. Miu, please stand. Raise your right hand. The clerk will administer the oath.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat in the witness chair. Mr. Nelson.
You're the Nick Miu we've been talking about for the past 7 days.
Yes, sir.
Nick, I want to right away talk to you about exhibit number 104, if I could have the screen. You were on the Apple River on July 30th.
Yes.
I want to ask you about this exhibit, which says it's from frame 2592 at 149 into the video. Have you seen this before?
Yes.
Do you remember that time in your life when you were on the river in that position as shown in that photograph?
Yes.
Sometime after that, did something happen to you?
Yes.
Were you punched and
Not,
attacked?
not before
Sometime
that.
after this, were you
After
punched?
that, yes.
Okay. I want to talk about the time between this and the time that you get punched, okay?
Okay.
Exhibit number 104 there is on the, with it. Where are you on that?
I'm standing in front of two ladies.
In which, if you were going to just describe the symbol on exhibit 104 symbolizing you, which one is that?
The one with the M.
Okay.
Do you
What
want the
color?
Do you want the
Blue.
annotator?
At that point in time, you said there's two people in front of you. Who are those two people in front of you?
A blonde lady to my left and a red hair lady to my right.
Were there other, does this accurately reflect how you remember roughly people in general around you?
Yes.
The blonde lady in front and the other woman, you understand now that through the trial that the blonde woman is named Madison Cohen?
Yes.
Can we use her name when possible?
Yes.
And the you said red-haired woman, her name's Riley Madison. Can we use her name when possible?
Yes.
Possible. So when Riley and Madison are standing in front of you at that point, just before you get punched, right? What are they doing?
They're yelling at me. At one point, they were pointing downriver and saying, "Go, go, get away."
What are they doing with their hands?
They're touching me.
When you say touching you, is that something gentle?
No, they're pushing. Madison, she pushed against my left shoulder. She pushed against my chest. She was pointing her finger right at my face. She was yelling at me very close to my face. Riley had one of her arms, I believe it was left hand, on my right arm, squeezing and pushing me back.
And when you just gave that description, you put your hands distance apart. Can you show us that again? How far away were they?
About a foot.
Okay.
Less than a foot.
You've heard it described through trial as in your personal space. Would you agree with that?
Yes, right in my face, I would describe.
When that was happening, what did it sound like to you?
The volume was very, very high.
Let me ask you about how your body was responding in that moment when people are pushing you, poking at you, the volume is high. How's your heart? Could you tell us about what your heart rate was?
Oh, yeah. My heart rate was getting really high. My breathing was getting very high. I was.
How about your vision? Did you have normal vision in that moment?
No. At that moment, because of the situation, I was getting tunnel vision.
Can you describe what you mean by you say in tunnel vision?
I couldn't see peripheral vision, but I could see center and right before my eyes.
How about hearing? Could you hear the noises?
I could hear the volume very high, but I couldn't understand what they were saying. The noise became garbled. I mean, the sound became garbled.
Did you feel threatened at that point?
Yes.
Did you have your knife in your right hand?
Yes.
What did you do with your left hand? Tell us what you did with your left hand.
Yeah, with my left hand, I pushed her away from my face.
Can you show us what you did with your left hand? Why'd you do that?
She was very close to my face. She was in my personal space. She had been there for a while, and I felt threatened.
Did you intend to harm her in some way?
No.
Did you try to harm her in some way?
Absolutely not.
Do you know where, if at all, you had contact with her body when you raised your left hand in that manner?
No.
Do you think you had contact with her?
No.
Okay. I want to take us out of that space now for a second, okay, Nick?
Okay.
If I could have the screen again. You were here in court when we talked about, when we watched the video of you speaking with Brandy Hart, is that right?
Yes.
And I think you told her about your health condition. Can you just tell the jury now, what was your health like on July 30th of 2022?
It was very poor. Okay. Yeah.
Had you, I think you mentioned to her again, had quadruple bypass surgery before?
Yes, sir.
And when did you have that?
2020, about the same month. So about August.
Showing you here what's been marked as exhibit number 108. Can you tell us what those are pictures of, starting just on the left?
Yep. On the left, it's me right after the surgery, holding a red heart pillow against my surgery.
What was the purpose that you knew of for that red heart pillow?
That was to protect my surgery from hits, bumps.
Was that something that the hospital provided? It looks like there's like almost a picture of heart and lungs on there.
It is. The hospital provided that.
And then the picture in the middle, what is that?
My first walk, my new life.
Did it take you some time to recover and be as active and mobile as you were before?
Oh, yeah.
Do you think you ever reached the same level of mobility and fitness that you were prior to the quadruple bypass?
Never.
What's the picture of you on the right there? You can tell us.
My baby.
Okay. Is that a dog?
Yeah.
Is that dog important to you?
My angel.
Okay. And that's the cushions helping you to enjoy time with her, but still keeping your chest safe.
Yes, sir.
Okay. You've had other surgeries in the past, is that right?
Yes.
Did you have a hernia surgery?
2 hernia surgeries.
Have you had back surgery?
Yes.
And again, in general, would you consider your fitness on, if you were going to put it on a scale for July 30th, what would you consider your overall health and fitness on July 30th of 2022?
With my weight and very poor.
I want to ask you now about moving on to the Apple River on July 30th, okay?
Okay.
On that, this was a planned trip, is that right?
Yes.
Did you get a call from your friend Ernesto sometime before that trip?
Yes, sir.
What was that call about?
He wanted to remind me to bring my knife to cut string when we tie the tubes together.
Okay, when you say, do you have a pocket knife?
Yes.
Okay, can you tell us about that pocket knife?
I owned it for about 10 years. I have it a lot on me. I use it as basically a dual tool. I call it my Swiss Army knife, basically because I use it as a screwdriver. I cut insulation when I do electrical work. I use it pretty much everywhere.
Okay.
I'm an engineer. My tool.
Is it something that you've carried on your person, I don't want to say all the time, but somewhat routinely?
Yeah, when I knew I was going to work on something or need it for something, yes.
Okay. Now I want to skip ahead again now to the river, okay? At some point, did Ariel lose his phone?
Yes, he did.
Did you go to look for that phone?
I volunteered to go look for it.
When you went to go look for that phone, what were you wearing?
Before that?
Nope, right when you
Oh.
left your group to go look for that phone, what were you wearing?
So I took my goggles, my snorkel, and my swimming trunks.
Did you have anything on your feet?
Yes, I had on my feet, I had a pair of really, really torn up sandals.
Can I approach, Judge?
Yes.
Showing you what's been marked as Exhibit 113. Is this a packet of 9 photos of your sandals?
Yes,
You seen those?
yes,
Does that accurately show the condition of the sandals that you had?
yes.
Can you just move to the admission of Exhibit 113?
The objection?
I don't think I've seen them, Judge, if I can take a look at them.
Yes. Oh, pardon, never mind, Mr. Anderson. All right, 113 is received.
These weren't taken by you, were they?
Pictures? No.
No, these were taken by the Sheriff's Department, correct?
Yes.
Permission to publish, Judge?
Yes.
Can I just, because we're going to go through the PowerPoint, can I?
Yeah, just pass them to the jury.
Can you use your words? I know we have a picture that better does it, but just briefly describe the condition of those sandals.
Horrible.
Okay.
They were just coming apart. I couldn't walk on them unless I tried to mend them.
Okay.
As you can see, I use string, leftover string to mend them.
When you left wearing those sandals and your shorts, Did you have your pocket knife with you?
Yes,
Where was it?
in my right pocket, clipped to my.
Did you have that there pretty much all day?
Yes,
You were here when we watched the video of your interview with Brandy Hart, is that right?
yes,
When you spoke with Brandy Hart, were you truthful to her about the knife?
no. I lied about the knife.
Was that your knife?
Yes, it is. It was.
Did you bring it with you when you went to go look for the phone?
Yes, I did.
When you went to go look for the phone, did you have any intent to harm anybody?
No,
Why'd you go leave your group?
go look for the phone.
Okay. At some point, did you have some contact with a group of teenagers?
Yes,
And you were here in court when we saw the 9-second video, is that right?
yes.
I want to show you just a couple of slides from that, if I could. Do you see those slides up there?
Yes,
Are those from that video?
yes.
What are you doing in those 3 slides in general?
I was scanning the water looking for the phone.
And are you, in that position, are you walking upriver or downriver?
Upriver, away from that group of boys.
Did you hear them say some things to you?
Yes,
Prior to your walking upriver and them, did you hear those words that I have written on that slide?
yes.
Prior to your hearing those words when you were walking upriver, had you had verbal contact with that group?
Think
They-
so. They asked me what I was looking for, and I told them I'm looking for a phone, a lost phone.
Did you ever tell them that you were looking for little girls?
No.
Were you looking for little girls?
Absolutely not. It's pathetic.
When you, at the end of this, when you watch the video, at the end of the video, where I'm not going to play it, but do you remember what you did right there at the end?
At the end, I was walking away.
Did you eventually turn around and face in the direction of the group that was yelling at you and calling you a raper?
Yes,
When you,
Yes. I'll sustain the objection. The question was leading. Please continue.
what did you do at the end of the video?
I was walking away.
At some point, did you ever become in a position where you were looking at that group of teenagers that had yelled at you?
Yes,
What did you see when you were looking at that group of teenagers after the end of this video?
I saw them. I saw one of them holding a phone in a bag, and I believed it was what I was looking for. So I turned around and I started approaching them.
Why did you approach them?
I wanted to get a closer look at the phone to see if it was the one that belonged to Ariel.
Did you eventually get near them?
Yes, I started walking, then I rushed the pace, stumbled and fell on my knees, held on to their tube, at which point I lost my goggle and snorkel kit in the water.
You saw in the video, or excuse me, you saw during your interview with Brandy Hart that you said things different than what you just said now about what happened to your snorkel and goggles.
Mhm.
Is that right?
Yes,
Is your memory sometimes different than what you see in the video?
yes.
Was your memory, in your memory, what happened to your goggles?
In my memory, the goggles got
Knocked away?
knocked away. Yeah.
Objection, reading.
So got
Hold on 1 second. When there's an objection, just wait on your answer. It is leading, sustained. Next question, please. It's a leading question. Let's move on.
Is your memory perfect?
never.
Now that you've watched the video, do you realize that you were wrong about that?
Yes.
What happened to your goggles?
My goggles fell in the water.
When they fell in the water, what did you do?
I started looking for them, searching right where they fell.
If I, oops, it's on already. Showing you here some slides, 220, 225, and 279. Can you tell us what you're doing?
I'm searching for the goggle kit.
And where are you in relation to the 6 teenagers' tubes? Are you on the side? Are you upriver? Are you downriver? Are you in some other position?
I'm upriver. So, yeah.
I'm going to then show you another group of slides, 575, 600, and 625. What does that show you doing?
So what I did from that point, I went around the inner tubes to the other side, and I continued looking for the goggle and snorkel set.
Why did you walk around from the one side to get to the other side of the tubes?
Well, I thought that the water current would bring him over to the other side, and I was walking away from the boys at the same time.
Okay. During that time that you walked in that direction, did you have any physical contact with them?
No,
Were you confronting them?
no. Didn't say a word.
This next set of slides, what does this show you doing here?
I'm walking away from the group.
Why?
Still,
Go ahead.
still looking for my goggles at that time.
When you were doing that, did you ever hear the kids say anything?
They gave me a warning.
What'd they say?
You got 10 seconds.
In response to that, what did you do?
I ignored them, and I actually continued doing what I was doing.
Okay. I can show you the next set of slides here. Were you in a position to see here 963, 1140, and 1155, what the teenagers were doing behind you?
They were getting closer and closer to me. They were walking towards me.
Were you in a position to see that? Was that behind you, or had you turned around?
Well, I could hear their voices. I could hear that they were getting closer. At some point, I may have turned my head and witnessed that. They're coming towards me.
Showing you 1170, 1213, and 1284. What's happening here?
I'm at an angle to them, but I could say I have my back at them, still scanning the water, and they were right behind me. They got that close. Within seconds, they were right behind me.
At some point, did you see other people from another group?
Yes.
What did you see?
I saw what seemed to me at the time adults coming over from the other side of the river.
And when you saw adults coming over from the other side of the river, what did you do?
I walked towards them. I walked towards this. The first one was a it was Madison.
When you walked towards Madison, where were the 6 teenage boys that had been yelling at you?
They're following me.
Were you in their path as you walked across the river towards Madison?
No,
Did they have as far as you know, did they have a clear path down the river if they wanted?
more than plenty.
Can I? Showing you this next group of photos. What's going on here?
So in this frame here, the first adult that came to me was Madison. She already had her finger pointing downriver and yelling at me and used some awkward words, ordering me to go down.
We see it looks like you're doing something with your right hand. Do you remember what are you doing with your right hand?
Yep, I was trying to explain to her what I'm looking for.
When you tried to explain to her what you were looking for, did you get the impression she was listening to you?
No, her voice was too loud to. Okay.
Hold on, wait a second. Sustained speculation.
I'm asking about his impression. So I'll rephrase. Did you get the impression that Madison Cohen was going to listen to your words?
No,
Why not?
because she was too loud. She never stopped to give me a chance to talk, and she kept pointing and ordering me to go downriver.
We've all heard the tape, but was she using polite language?
Polite? No.
Did you hear anyone saying anything behind you when you walked over to Madison Cohen?
Yes, they're all calling me names.
Okay. Showing you the next set of slides here, 1776, 1840, and 1824. What are you doing here in this set of slides?
I'm turning my back towards Madison and the rest of the people.
Why did you turn your back to Madison and the rest of the people?
It felt to me like I couldn't have a conversation with her at that point. She was not listening, and I didn't want to interact any further.
Had you at that point found your snorkel or goggles?
No,
Had you at that point found the phone?
no.
Did you hear anybody saying anything while you stood there with their back to them?
Oh yeah,
What did you hear?
they were still yelling. He's looking for little girls.
Were you looking for little girls?
Absolutely not.
When you heard them, did you consider that to be a lie?
Objection, Your Honor. Leading.
Sustained.
I asked, did you consider that to be a lie? I don't.
Yes,
think
of
that's-
Hold on, please.
Don't think
I
that's legal.
sustain the objection. Please move on.
When you heard that, did you consider it to be truthful or did you consider it to be untrue?
Untrue.
And when you heard someone say an untruth about you, did that change how you were feeling?
I felt frustrated. I felt annoyed. They kept saying it over and over, so it annoyed me and frustrated me.
And when you heard them say this untruth about you, did it appear to you as if the other group that had come over agreed with what these the teenagers were yelling about you?
Objection, leading.
Sustained.
Did you think anybody in the other group was going to help you or listen to you when you were being called these names and accused of being a pedophile?
Objection, leading.
Sustained.
How did you feel?
Well, I felt overwhelmed at that point. I felt still annoyed, frustrated. I felt like she wasn't listening. She was the adult I thought I was going to reason with or get help from. She obviously didn't even attempt to reprimand the children from yelling.
Showing you another slide here. Some 1838, 1846, and 1865. Is that you?
Yes.
What are you doing?
Judge, can we protest?
Yes. Just one moment. Ready? Okay,
Yes, sir.
let's continue.
Showing you photos 1838, 1846, 1865. What are you doing in those? Do you remember what you were doing?
Yeah, I had my back towards the group of people.
In the two photos there, which direction are you looking?
I'm looking downriver.
Okay. Are you looking at, there's two different groups, if I recall, from Exhibit 104. Is that right?
Yes,
One came from one side of the river and the other one's on the other side of the river.
correct.
Where are you, in the photo on the upper left, are you looking at one particular group as opposed to another group?
Yes, I'm looking at the boys group
And why are you looking at the boys group?
because they were yelling at me.
And what were they yelling at you?
They were yelling things that were not true and pointing at me.
When this, I want to, after that happened, showing you the next group of slides, 1875, 1883, and 1889. Do you remember what Madison did, if anything, to you?
Yeah.
What did she do?
She grabbed my right arm and she pulled me towards her and I lost my balance. So I moved towards her.
Did you consider that in that circumstance to be a gentle or a gracious touch?
No, that was not a gracious touch. No, not at all.
Had she been using any gentle or gracious words with you?
Not that, no, not that I remember.
In those photos, can we see the footwear that you were wearing on that day?
Yep, those sandals that we saw earlier.
Did you have confidence in your footing in that area with those sandals?
Objection, reading.
Sustained.
How did you feel about your footing in that area?
Very unstable.
Want to show you the next set of slides here. Do you remember what you say to Madison after she pulled on your right arm?
Yeah, I told her not to touch me
And why did you tell her that?
because she pulled on me without my invitation.
Did you say that in any particular tone?
No, not in a mean tone, but I made it sound so she could hear me. Don't touch me.
Okay. Why didn't you want her to touch you?
I didn't give her permission to do so
Sure, but why did you not want to give her permission to do so?
because she was one track mind. She just wanted to get me away from that, point me down river and tell me to go there.
What's your comfort level at this point?
On a scale from 1 to 10, comfort level is very low.
Okay. Are you, if you had that same thing, a scale of like a fear scale, a 1 to 10 fear scale, right? And so with 10 being the most fearful you've ever been in your life and 0, let's call 0 to 10 being the most safe you've ever felt.
Mhm.
Where are you at here on a fear scale?
In that particular,
Yeah.
about 1.
Okay. So you're more uncomfortable, but not necessarily afraid. Is that what I understand?
Correct.
At, where was your group in relation to you then?
Was upriver.
And did you do anything in order in relation to your group?
Yep.
What did you do?
I turned to them and I called them. I was trying to call them to come over and help me.
Are these slides, does this 2127, 2140, 2131, what does that show you doing?
I was waving at them and calling them to come over.
When you say you were calling them, did you do something physical or did you something verbal or did you do both? Showing you another set of slides here, 2328, 2311, 2382. Do you remember, what do you remember about that?
I remember the young boys are yelling, pointing at me, saying things that are not true.
Were you able to see, like in this next slide, this 2429, 2440, 2401, were you able to see as you stood there what everybody was doing? And were you able to scan and see that?
For a brief second, yes.
Okay.
They were very close. They were really close to me. I could see and hear them.
How about your fear scale there? Where is it? Where is it?
About 2 or 3.
Okay. I see in the one on the right there, you have your hand someplace. Can you tell me what you're doing with your right hand?
Yes, I'm reaching for my pocket knife.
Why?
Because at one point my fear was getting really high, and
Okay.
I was getting ready to pull it out.
Okay. Do you remember, other than what you've talked about, Madison Cohen pulling you, which we saw, do you remember anybody else touching, pushing, grabbing you in any way?
The 2 ladies, yeah.
Do you showing you here what's 2472, 2478, 2481. Do you remember what's happening in those photos?
Yes. This one, the lady on my right side, she grabbed my arm and she was pushing against my arm.
And did that increase your level of comfort or increase your level of fear or something different?
So it decreased my level, the level of comfort, and increased my my fear.
Do you remember at some point, do you take your knife out of your pocket?
Yes, I do.
Do you know when that is in relation to these slides? Do you have a memory exactly of when that is?
Not exactly, but when they were pushing and poking at me, I remember I pulled it out then.
Okay. Do you remember, did you have it out before you were punched or after you were punched?
Before I was punched.
Okay. Showing you another set of slides here. It looks like do you remember doing something with your left hand?
Yeah, at that moment, I really needed my people to come over and help me. So I was trying to get their attention.
One more slide here. Do you, what's happening here in the slide?
Madison is pushing on my left shoulder and basically yelling at me right in my face.
And then on the next slide, we see something in your hand. Is that right?
That's a knife.
Why did you take out your knife at that point?
I was beginning to be afraid.
And what was it about that moment where everybody is that made you so fearful that you took out your knife?
I was surrounded. They were yelling. They had just pushed me. Well, the lady, they squeezed my arm. I mean, it seemed like they were not backing away.
Previously, you turned around. Is that right?
Yes.
Did you feel comfortable turning around in this situation?
No.
Why not?
They're too close to me.
What happened the last time that you turned around?
Nothing good.
Judge, this
Good place to break.
may as well be.
All right, 12 noon, let's break for lunch. All right, Mr. Miu, would you please retake the witness stand? You are still under oath. Mr. Nelson.
Thank you. Can I have the screen? Mr. Miu, when we finished, I think we were getting to the chronological space that we had begun the morning on. And so I want to start from there again and then move forward from there. Does that make sense?
Yes.
When I had asked you before, you talked about how you felt, but since that time, you've told the jury that you had this fear scale. Okay?
Mhm.
So I want to ask you about, at this time, what we see here, what you previously described the scene, right?
Mhm.
How were you feeling on the fear scale?
About the 6, 7.
Okay. And at some point, I think you told them before, but just so we can put it into the context here, did you do something in response to something that was done to you when you're standing there in this moment?
Yes. After I was pushed in both sides, I would say, squeezed, I was afraid, so I pulled out my knife.
Okay. Did you do something with your left hand at some point?
Yes, I did.
What'd you do with your left hand?
I pushed her away. I
And when you
pushed
say you
Madison.
Push
away.
Madison away. Was the purpose in that to have contact with her and to get her to back up?
Yes.
Did you have a purpose to cause her pain?
No.
Were you trying to hurt her?
No.
What were you trying to do?
I was trying to push her away from my space. She was right in my space, my face.
Why didn't you just back up?
Couldn't back up at that moment.
Okay. When you say you couldn't back up, why not?
I
Because
would've-
you felt uncomfortable or were you?
Objection leading.
Because I would have had.
Wait, there's an objection. Sustained on leading. Next question.
Wasn't done with it. Were you uncomfortable or was there a wall behind you or was there some other reason? Why did you feel like you couldn't back up?
I didn't feel safe turning my back on those people.
Okay. How about just taking a step backwards?
Well, I was standing my ground. I didn't move towards anybody.
Okay.
They're coming at me.
When you raised your left hand and you did that, do you recall when you pushed her away having contact with her?
I may have, yes.
Okay. Do you remember in particular where, if at all, you touched her?
No.
Okay. Would it surprise you if you touched her?
No.
Was that, in fact, your purpose in pushing her away?
Absolutely.
Okay.
She was in my space.
I want to move forward here. And you can turn the slide off, I guess. After you did that, right? Did something happen to you?
Yeah.
Did people do something to you?
Yeah.
What was done to you?
Yeah, almost right away I got punched and fell in
And
the water.
where did you get punched?
On my face, on my side of the head.
Now, you've had a chance to watch this video, correct?
Yes.
Have you had a chance to see these 4,800 slides?
Yes.
Prior to seeing that, did you remember everything?
No.
Have the video or the slides help you to refresh your memory in some way?
A lot.
Have you remembered everything because you've seen that?
Not everything, no.
Okay. Do you remember something different than what you see in the video?
No.
You don't remember any of the things different in that you see in the video? Like you talked about the goggles.
Objection leading.
Overruled. We're just trying to reorient the witness to a place where examination can continue.
Are there some times when your memory is different from what the video is?
Yes, of course.
Okay. Now, this series that I want to show you is about things that were done to you, okay?
Yes.
Do you have a specific memory about everything that was done to you?
No.
Do you have a specific memory about everything that you did in response to what was done to you?
No.
Do you have a memory about how you felt in those moments?
I would say yes, I do.
Do you have a memory of what you believed in those moments based upon those feelings?
Of course.
So I want to show you the slide here. Again, this is slide 2661, 2662, and 2681. That's fine. Do you remember how you felt when you fell back into the water?
I was, number one, I was stunned. That's why I fell backwards. I was very afraid, of course.
On this fear scale that you've talked about before, where are you on that scale from 0 to 10?
Right at the top, 10.
Have you ever been at that 10 before in your life?
Never been in a situation like this or a fight in my life.
Have you ever been at a 10?
Never.
When you did that, as we see on the right, what happened to your head?
Oh, well, I fell in the water. Obviously, that's a river, and I hit my head on river rock, and my whole body went under. Well,
Okay.
my head went underwater.
When you say your head went under, is that what it felt like?
Yes,
Did you feel water come over your face?
over my entire body.
Hold on,
Yes.
hold on. What's the objection?
Bleeding.
Sustained.
Where did you feel the water on your body?
Over my face, my mouth.
Okay.
I felt like I was submerged in water at the moment.
Did you try to get up?
Yes,
Why did you want to get up? Why didn't you just lay down there peacefully in the water?
to drown. No, I wouldn't want to do that. I wanted to get up out of the water.
At that moment, when you're down in the water, had anybody like AJ Martin come up to you and said, just lay there and rest?
Somebody came from behind. Yes, I found out later who he was and pushed me down and to keep me in the water.
Before that, when you tried to get up, do you remember feeling anything before that? Did you told the,
Yeah,
did you feel anything to any part of your head?
yes, of course.
What did you feel?
Felt punched in the head.
Showing you the next slides, is that 2701, 2705, 2706? What's happening to you there?
I'm getting hit on the head.
How many times at that point, is your memory of watching the video and your memory of experiencing this, have you been hit in the head now, but either by people or by the ground or by the water?
4 times at least.
Okay. At this point in time, where's your fear scale?
A 10.
When this happened to you, did you immediately get up or did you fall back in the water or did something else happen?
I tried getting up, but I couldn't.
Did you, at some point, did you feel something on your backside?
There was somebody pushing me down.
And when you felt that on your backside, did you feel anything else anywhere else?
I got hit in the face, in the front of my head.
And is that exhibit here, 2147, do you see that hand through the underarm there?
Yes,
Do you remember getting hit in the head there?
yes,
Was that a gentle hit?
no.
When you're getting hit in the head here again, where are you at on the fear scale at that point?
10,
Have you been able to get up out of the water?
no.
How many people do you know? How many people are attacking you?
At the time, I didn't know, but I knew there were more than I could handle.
Did it feel like it was, how many people did it feel like?
Like 10.
Okay. You've seen the video and you responded at some point, is that right?
Yes,
And you used your knife in response.
yes.
Why do you use your knife?
I feared for my life.
Did you think you could get out of there without using your knife?
I couldn't even get up. They're pushing me down. No, so the answer is no.
In that time when you're down on the ground, did you think there was a way for you to escape?
No,
Did you feel like you could just crawl away or run away or walk away or do anything else to escape?
not in that position.
The next day after this, July 31st, were you in the, did you feel, how did your body feel the next day?
I hurt everywhere. My head hurt, my throat hurt. Obviously, my back hurt. I hurt everywhere.
You said your throat hurt. Is that something you remembered that day before when you were speaking with Brandy Hart?
Yes,
Okay.
Yes,
Did you mention it to Brandy Hart?
I don't remember.
Okay. Did you see anything when you felt the pain about your throat? Did you see anything that refreshed your memory about what caused that pain to your throat?
After watching the video, yes.
What happened?
I got hit in the throat.
Do you remember
Really
that
hard.
now?
Yes.
If I can. Showing you the slides 2993, 2994, and 2997. Is that you?
Yes.
What's happening to you there?
Somebody is going for my throat, squeezing my throat.
Do you remember how that felt?
I felt pain. I couldn't breathe. Scared, afraid.
And showing you the next set of slides here, 2998, 99, and 3000. What did you think was going to happen to you in that moment?
The whole time I felt like I was going to die. So basically I feared for my life.
And in response to that, here's slide 3000. Did you do something in response to that?
I reached out and stabbed him.
When you used your knife, and again, this is open-ended, you can ask it any way you want. Were you trying to kill somebody?
Absolutely not.
What were you trying to do?
I was just trying to defend myself.
After this was, again, we've seen the video, you talked to investigator Hart. So I want to ask you a little bit about that for a moment. Make sense?
Mhm.
Do you independently, well, let me say, you've watched the video here in court, correct?
Yes.
And you watched the video prior to that. We've watched it together, right?
Yes.
Does watching that video refresh your memory? Do you have an independent memory of that conversation with investigator Hart?
No.
Do you remember what it is you said other than seeing things on the video?
Other than I lied about the knife. That's what I remember, afterward. Yeah, I lied about the knife.
Do you remember actually saying that in that moment, or you just remember seeing that and that's what you remember seeing?
I remember seeing it in the video.
Okay. Do you remember how you were feeling during that time at all? Do you have any memory about that?
Not much.
Just one other thing out of the timeline here. Since that time, we've heard testimony, you have a twin brother.
Yes.
Is he here in the courtroom?
Yes.
Objection relevance, Your Honor.
Overruled. You may continue.
Just briefly, because I want to ask you about conversations that you may have had with your twin brother. Just briefly. How do you feel about your twin brother?
I love him.
Objection, that's irrelevant, Your Honor.
Overruled.
During this time, have you had conversations with your twin brother?
Yes.
Do you consider there to be anybody that you're really, maybe your wife, anybody you're closer to than your twin brother?
No.
You and your twin brother, when you speak, what language do you speak in?
Romanian.
Why do you speak in Romanian with your twin brother?
It's the easiest way to find words to describe what we're thinking.
Okay. Is that where you grew up?
That's the first language.
Are there times when you've spoke with your brother that you've talked about this, what happened to you on the river?
Yes.
Is your memory about what you did or what was done to you, is it any better when you talk to your brother than it is when you talk about other times?
No.
Are you always getting it right?
No.
How about your feelings? Your memory about your feelings?
Mhm.
Do you get those right?
Yes, but almost all the time. The feeling is imprinted in my heart, my soul, my mind.
Let me, just for a moment, I'll bring us back to the river on July 30th, okay?
Mhm.
At I think you'd said on the video and maybe you testified that people attacked you. Is that right?
Correct.
At some point, did people stop attacking you?
No.
At some point, did people stop attacking you?
Yes.
Okay.
Yeah.
When people stopped attacking you, what did you do?
I walk away.
Okay. Why didn't you stay?
Oh God. I walked away towards my group where it was safe. I was afraid of the people that I just had contact with.
When you're walking away, where, and you've talked about this fear scale, where are you on the fear scale? Does it just go down right to 0? Does it stay at 10? Does something else happen?
No, as soon as I saw the people I trusted, my fear level started creeping down.
When you say creeping down, when you're walking back, can you give us where are you on that scale?
As I was getting closer to my group, the fear factor is going lower and lower.
But when you first start walking back, what's the number value?
About 8.
When you get back to the tubes, what's the number level?
About 4, 5.
I think we didn't talk about it. We've talked a little bit about your body response during this brief time. When you start walking back, how's your body responding to you?
I had cramps. I felt like I had diarrhea, so I felt like I lost my bowel.
Was that
which I did?
Was that when you were walking back, or was that when you were in that 10 seconds of things happening to you and you responding?
I was when the action was going on in the 10-second frame.
You got diarrhea.
Yes.
When you were walking back, what else is your body? What are you feeling with your body?
Well, heartbeat is getting, when I'm walking back, the heartbeat was very, very high. Now it's going down a little bit. Breathing, that's what I remember. Remember, I was super, super stressed.
How about your head? As you're going back, is your head clear? Is your head in a different state? How can you describe like what's going on in your head?
My head was in a fog. It was like thick fog. I couldn't think. I couldn't realize what I've been through.
Were you trying to make sense of it?
I was trying, but there was no sense to be made. I was completely confused and in a fog.
And when you walked away, you had the knife in your hand. Is that right?
Yep.
When you got to your group, did you still have the knife?
No.
What happened to the knife?
On the way back, I tossed it on the bank.
And you just made with your right hand kind of a underhand motion with your right hand from, at your side, raising up to maybe level with you. Is that fair representation of what you were describing?
Correct.
Why'd you toss the knife?
I don't know. I was afraid. I felt like I had to throw it away.
What were you afraid of at that point?
I was overwhelmed with just fear, residual fear. And I didn't want to have anything to do with that.
Okay. We've heard testimony that eventually you get back to the tubes. Does that happen?
Yeah.
Where's your memory about that? Right now, as you sit here, because we don't have a video about that, we don't have photos of that. What's your memory like about that?
Barely remember anything.
Okay. Do you remember talking to people?
I remember people trying to talk to me, but I don't know. I don't remember what I said.
Okay. You've heard some testimony about things that you might have said. Are you denying you said any of those things?
No.
Do you know what you said?
After watching the video, yes.
The video isn't I'm confused. The tubes, there's no video of you at the tubes. When you say.
After.
Were you talking about Brandy Hart's statements?
Yes, yes.
Okay. About what you said to the people at the tubes. Do you have any memory of that?
No.
Okay. When you're sitting there at the tubes, how are you feeling in your head? You talked about this fog, right? If you could put that on a scale, where is that?
I still couldn't, my head was in a thick cloud. I couldn't understand what just happened. Still trying to process everything. I was overwhelmed.
Did you think at any point you were just casual about what had happened?
No.
Did this feel casual to you in any way?
No.
At some point, you saw the video here. You had contact with the police, is that right?
Yes.
You had sat in the back of a squad car of the Sheriff Knutson, is that right?
Yes.
Do you remember much of anything about that?
No.
Do you remember, you've seen some of the videos today?
The 9-second video that's been played multiple times. It's only 9 seconds. The other video I don't think has been played in entirety only once. So I don't have any objection to the main video being played.
Mr. Trophy?
Judge, if you may, not sitting in the right seats, I apologize, but if it's played, I think it needs to be, they need to be brought into the courtroom and it
Yes.
needs to be played in here. That,
My judgment, the jury is entitled to see the evidence, and this has been a multi-day trial. There's lots of things to consider. There are lots of nuances in the jury instructions. So I think it's reasonable for the jury to re-examine exhibits. They can't have the video in the deliberation room, so they'll have to come out into the courtroom to see it. If the jury thinks that watching both videos will be helpful to their deliberations, they're entitled to see both videos. So we'll have them brought back in and we will play them both. I'd like to have the videos played in chronological order. So we'll start with the 9-second video, watch it, and then we will move on to the next video. Now, when they come in, this won't be the opportunity for Q&A or comment or discussion. The opportunity for persuading the jury is over. I may ask the jury if they want to see it again because it moves fast. So if they want to see it again, we'll play it again. But I'll be the one doing the questioning. Any questions about the process?
Who do you want to play it?
It doesn't matter.
I don't have my computer, so I'm happy to go get it, but
I can do it.
Okay, so you'll play the video. I'll give you the cues to start.
and I'm sure Your Honor will, but I would imagine when they come in, Your Honor is going to tell the jury as well that this is not the time for questions and answers.
Exactly, right.
Excellent, perfect.
All right. We stand in recess until they come back.
Do I have time to go out or not? Should I wait?
Why don't you wait? I think this-
Okay,
This won't
that's fine.
take very long. We are back on the record, State versus Miu, with the attorneys and Mr. Miu present in the courtroom. The jury has a question, I guess, a request really. They'd like to see both of the Juwan Cockfield videos. Mr. Anderson, your comments?
The 9-second video that's been played multiple times. It's only 9 seconds. The other video I don't think has been played in entirety, only once. So I don't have any objection to the main video being played.
Mr. Trofasi?
Judge, if you may.
Not sitting in the right seats, I apologize, but if it's played, I think it needs to be, they need to be brought into the courtroom and it
Yes.
needs to be played in here. That,
My judgment, the jury is entitled to see the evidence, and this has been a multi-day trial. There's lots of things to consider. There are lots of nuances in the jury instructions. So I think it's reasonable for the jury to re-examine exhibits. They can't have the video in the deliberation room, so they'll have to come out into the courtroom to see it. If the jury thinks that watching both videos will be helpful to their deliberations, they're entitled to see both videos. So we'll have them brought back in and we will play them both. I'd like to have the videos played in chronological order. So we'll start with the 9-second video, watch it, and then we will move on to the next video. Now, when they come in, this won't be the opportunity for Q&A or comment or discussion. The opportunity for persuading the jury is over. I may ask the jury if they want to see it again because it moves fast. So if they want to see it again, we'll play it again. But I'll be the one doing the questioning. Any questions about the process?
Who do you want to play it?
It doesn't matter.
I don't have my computer, so I'm happy to go get it, but
I can do it.
Okay, so you'll play the video. I'll give you the cues to start.
and I'm sure Your Honor will, but I would imagine when they come in, Your Honor is going to tell the jury as well that this is not the time for questions and answers.
Exactly, right.
Excellent, perfect.
We stand in recess until they come back.
Do I have time to go out or not? Should I wait?
Why don't you wait? I think
Okay,
this won't
that's fine.
take very long.
Who is that? Where's the culture? Who is that? Who the hell is this? Go. It doesn't matter. He's running. He said he was looking for little girls. He said he was looking for little girls. Yeah. That's exactly what he said. Weirding us out. I even have that part on camera. Did I? Some young ass kids. What the hell is this guy's problem, bro? We trying to have fun. If he's gonna claim you, he's gonna claim you. We don't want this motherfucker. Let it on camera. Let it on camera. He on camera. Oh God. Oh God. He on camera. Oh God. He on camera. He hit a woman? He hit a woman? You hit a woman. He hit a woman. You killed him. What the fuck? What the fuck? Wait. What the fuck? He's dying. He's dying, bro. Wait, what? What? Oh my god. Oh my god. Oh my god. Oh my god. Are we serious? Is this real? Oh my god. Who is that? Oh my god. Is this real? Is this real?
Oh my God. Oh my God, what the fuck?
Is this real? Is this real?
Fight! Bro, fight!
That's not bike! That's not bike! That's not bike! That's not bike! That's not Isaac! Oh my God! Oh my God! This isn't real! This isn't real!
Anybody need to see it again? Want to see it, the entire? Or do you want to stop it at a certain point? At the very end? Let's take the video down. Mr. Anderson, if you can get the video, I'll put it, I can see it on my screen. They can't see it up there. Put up the video. And I'd like to get it to a point where I can end it. But I want to see it first so I can tell you where. I can't see it. My mistake. More. That's it. So it's about 2 minutes, 25 seconds, 27 seconds. All right, let's put it up.
Yeah, that's fast. What is he on? Whoa! 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 Get away! Whoa! Oh God! We up! We up! What are you talking about? What the hell are you talking about? What? Get away from us! What? What's going on with y'all homie? He's on camera, tripping. He's on 4K. Yo, the new iPhone got that good quality. What did he say? Yeah, what the hell? Who is this? Yes, yes, yes. For the culture! For the culture! Who is that? For the culture! Who is that? Who the hell is this?
No, it doesn't matter.
He said he was looking for little girls! He said he was looking for little girls! Yeah!
That's exactly what he said.
Weirding us out. I even have that part on camera. Dead ass.
Some young ass kid.
What the hell is this guy's problem, bro? We trying to have fun. If he's gonna claim you, he's gonna claim you. We don't want this motherfucker. Let it on camera. Let it on camera. He on camera. Oh God. Oh God. He on camera. Oh God. He on camera. He ain't a woman. He ain't a woman. You ain't a woman. He ain't a woman. You killed him.
That's where we're going to stop it. Yeah, thank you. Anybody else need to see it or a different part? Everyone's good? All right. The jury or the bailiff will take you back. Please continue your deliberations.
All rise for the jury.
be seated. Mr. Anderson, anything for the record?
No.
Mr. Trofficy?
No.
All right, that's all. We're in recess. Do you have the jury list?
Okay, right. I think I'm just going to end the stream for today because it doesn't look. We had one question. One question I think he had. They had a video question today, and the judge refused it. So I try to catch that for you guys live. I will keep an eye on this. I'll probably go live tomorrow morning. I can't see them coming to a verdict today. There's another 3 hours to go, but I can't see it. Not today, anyway. I think it might be. I'll be back tomorrow. So what I'm going to do tomorrow is I'm going to play a few videos. I'll play the Tragos one of Miu's testimony. He's reviewing that and stuff. So I'll play that. And yeah, I'll play some other videos whilst we wait. I think that's what we'll do. So as I said, I'll be back tomorrow with it. There's no point sitting here all day waiting because it's the worst part. I will, as I say, I will go live when it's time to go live. And yeah, we'll take it from there. I mean, Apple River, you got Fox 9 local, that's streaming all day long. That's just going through loads of testimony and stuff like that. So you can watch that if you want to. If you're that into the trial. But I say I'll be back probably 8 o'clock tomorrow morning, Central Time, 9 o'clock Eastern Time, unless there's anything tonight. If there's something tonight, that's different. But if not, I'll see you tomorrow. Just a couple of questions here. Well, I missed the last part of closings. I missed, not really. I missed standard stuff then. Standard stuff. I think he acted in self-defense, but wish someone didn't die. Yeah, absolutely. It sucks. So I'm sure he will be charged with something because a kid was killed. But then again, with most of the jury being older, they might be able to put themselves in issues. It's a big question of whether self-defense or not, isn't it? And then if they say yes, then which charge he goes into. I blame those damn kids on their skateboards. Lovely on the tubes. Right, people. Again, thank you everybody as always for your support. I hope you've enjoyed this trial. We're just on the conclusion now, and we've got Karen Reid starting next week. That's my next trial. So for those of you that want to follow Karen Reid, there's a hearing on Friday. I will try and stream it depending on if this has got the verdict or not. So we'll see if I stream that or not. But if I don't, I'll try and stream it at some other point anyway. Then on Tuesday, we are streaming Karen Reid with my co-host, special guest, Sean El Jefe McDonough. So we got Sean coming for Karen Reid the whole trial. So it's jury instructions on the Tuesday. But I'm not sure if they'll show that. But if they don't, that's fine. We'll just chat about the case and stuff like that on Tuesday then. So it's fine because Tuesday's only half a day anyway. So court in Boston for the Karen Reid trial. Monday, Wednesday, Friday, full days. Tuesday, Thursday, half days. That's the plan that they have there for that. So on Tuesday for jury, when they're picking the jury, we probably won't get to see it. But like I say, we'll just have a chat then for 3-4 hours, go through some stuff about Karen and take it from there. So with that, everybody, keep your notifications on, hit your notifications. We will be going live as soon as the verdict, or as I say, I'll come live tomorrow to play some videos to keep some people company if they want some company. So with that, everybody, take care of yourselves, and I'll see you tomorrow. Or if there's a verdict, see you later. Take care. Ta-ra. Free Zachary Anderson.